everything's settled. I think we got everything settled. Thank you, ladies and gentlemen, for being patient with us. We've had a kind of a crowded calendar today, so we're about to get started on it. Tyler Paul, could I call on you to start us off?
Number 13. Thank you, Mr. Chairman. Bay heads, Lord, we come to you today with thankful hearts. Lord, thank you for letting us wake up once again. Lord, help us to understand our purpose. Help us to do things here, Lord, and the rest of this session that would be pleasing unto you, Lord, and serve your purpose. In your name we pray. Amen.
Amen.
Thank you. All right, let's see what we got on the list. Chuck Martin, are you here?
No, but there's a guy that looks at
Oh, there he is. Come on up, let's do your bill.
This is going to be so quick that I need to even sit down.
Your choice.
Mr. Chairman, I bring for your consideration today House Bill 392 LC 280667. What this bill does is a cleanup of our move. There was enabling legislation and a constitutional amendment last year that moved the tax tribunal into the judicial branch. All the learned members of this committee know about the administrative court and the process, the appellate process that goes through. This is just a much cleaner process, keeping a court that's specifically in tune with the items that it will hear, but allowing the appellate process to go directly to the Court of Appeals. Because as I understand in Georgia, there's only a guaranteed one level of appeal, and this was putting, as administrative court, that's to the superior branch. So that's where the reason we moved from a tax tribunal to a tax court. This is just cleanup language that we needed to stand up the court. And if there are any difficult questions, Mr. Chairman, I would yield to the second signer of the bill to answer those. And if he's not available because he's chairing the meeting, I would yield to my distinguished colleague from DeKalb County, Representative Mary Margaret Oliver, as the third signer of the bill. She also knows this matter well.
All right. I don't think we had anybody sign up on the bill.
In all seriousness, Mr. Chairman, this is just a cleanup in order that the court can get started in the proper manner and transition, handles the transitions of any cases ongoing in the tribunal as it moves over to the judicial branch.
Okay, I appreciate you bringing this bill. Anybody have any questions for the author? Do I hear a motion? Got a second? Okay, got a motion and a second. Any further discussion? All those in favor say aye. Aye. Any opposed? All right, there you go.
Thank you, Mr. Chairman. I just want to tell you all those rumors out there about you guys being hard to deal with. I'm going to go out there and set out to the contrary. Y'all are very thorough. All right, see you.
All right, do you want yours next?
Let's get some other folks.
Who's next?
Some news here. I'm Chairman Leverett's not here.
Yeah. Oh.
Yeah.
All right, let's see.
She's got.
Representative New, you want to do yours? All right. 251.
Thank you, sir.
We got people supporting it.
May I ask Kevin Holder, he's the Executive Director of the Council of Probate Court Judges, as well as Judge Bobby Wolf. He's the President of the Council of Magistrate Judges, to sit with me, please.
Sure.
Thank you, sir. Members, appreciate your time. Which one you want to start with? Probate?
Yes.
All right. Thank you for the opportunity to speak to you today about House Bill Resolution 251. We're working with LC 473339. This resolution proposes an amendment to change the Constitution that would ensure all probate judges are elected in nonpartisan elections. It also includes a plan for the change to be approved or rejected by the citizens of Georgia. We need this bill because, as we heard from Chief Justice Boggs during his State of the Judiciary on our House floor, that judges should be running nonpartisan. That's the way we maintain the public's confidence in an independent judiciary system. A judge's duty is to impartially follow the Constitution and the law, and there is no room for partiality or partisan politics on the bench. Requiring some judges to run in partisan elections makes it difficult for them to comply with the Code of Judicial Conduct and maintain impartiality and the appearance of impartiality. And also, I'd like to throw in that the Judicial Council and the Council of Probate Court Judges, as well as the, for this one, the probate judges, support this legislation. Thank you.
All right. Any questions by the committee? All right. I don't think we have any.
We got some people are speaking.
What now? Yep. Those of you that signed up to support, do y'all wish to still do that? If I can hear from anybody. You still want to come up? Okay. Thank you.
Wow.
All right. Now, do I hear a motion?
Motion to pass.
All right. So we got a motion and a second. Any discussion?
Which one? Oh, Richard.
This is HR 251. All right. All those in favor say aye. Aye. And a like sign for those opposed. All right. Your bill passes.
Thank
Your
you.
resolution passes.
Thank you, sir. And now I'd like
I
to...
got 426.
Yes, sir. Magistrate judges, nonpartisan, HB 426. We're working with LC 473367. This bill proposes nonpartisan elections for all magistrate judges. It also places magistrate and probate judges, should the constitutional amendment pass in 2026, under the same code sections that provide for how and when nonpartisan elections are held. We need this one, as I've already stated. We need this because, as we heard from Chief Justice Boggs during the State of Judiciary address, that judges should be running nonpartisan. The duty is to be impartial and to follow the Constitution and the law, and there's no room for partisan politics with any judges. And requiring these judges to run in a partisan election makes it difficult for them to comply to their code of conduct. So I would appreciate your support and your consideration for this matter.
Okay. And Judge Wolf, you...
I would just echo all that. Thank you to everybody for having us here today. I'm Bobby Wolf. We support HR 251 and HB 426, requiring all elected magistrate and probate judges to run nonpartisan. I wanted to mention most elected magistrates already run nonpartisan. This is a small group to bring them with the rest of the group. Again, a judge's duty is to impartially follow the law and the Constitution. No room on the bench, in my opinion, for partisan politics. And so requiring any judge to run partisan makes it really hard to comply with the Code of Judicial Conduct. So Chief Justice Boggs, I want to thank him, the Judicial Council. Our council supports it, the Probate Council supports it, and we ask you to support this legislation as well. Thank you.
All right. Who's got number 11? All right. Representative Hong.
Thank you, Judge. Thank you, Chairman.
And I want to thank Representative Muir in particular. Thank you.
Thank you, Chairman, and thank you, Representative, and good seeing you, Judge Wolf. Just curious, how many counties are partisan versus not currently?
So there are 111 that are already nonpartisan, and the rest are partisan.
Thank you.
Yes, ma'am.
Okay. Any other questions by the committee? All right. Do I hear a motion?
Move to pass.
A motion and a second. Any further discussion? Seeing none, all those in favor say aye. Aye. Same sign for those that oppose. All right. Your bill's through.
Thank you, sir. Thank you, members. Appreciate your time.
Thank you.
All right. Okay, I think we're coming around to you.
327.
Let's see. Oh, he's here now. Okay. Chairman Leverett?
No,
was kind of a thrill, so thank you.
Chairman Leverett, you ready to go?
Need Kyle. Could you share Kyle?
I understand.
Sorry, I had to say hi to a bunch of probate judges.
I understand. I know the importance of that.
Whenever you're ready.
Thank you, Mr. Chairman, members of the committee. This is House Bill 327. It's a simple, short little bill. It's LC 481418. So we're dealing with the as-filed version, no substitutes, at least at this point. And so this is the fiduciary law section's sort of code rewrite, code revision bill. We've made a number of changes to laws of will, probate, administration of estates, guardianships, trusts, and those kinds of things over the last 25 years. We had the probate code. It was completely revised in '98. Guardianship code was revised in 2005. Representative Evans, just you might be of interest in that. Trust code was revised in 2010, and the Uniform Power of Attorney Act was adopted in 2017. And the General Assembly adopted amendments to these revisions in 2018 and 2020. So 327 makes additional amendments to conform existing law to those original code revisions, correct mistakes in drafting, address problems that became obvious only after years of experience, in courts with the original code revisions, and to make reforms to the code based on recommendations of lawyers that practice fiduciary law in Georgia. So just broadly, that is what the bill does with respect to the law of wills and other things of that nature. And that is part of the reason that is rather lengthy. Now, I believe we do have a rule here about phone a friend, Mr. Chairman.
Yes, sir.
As I recall, I'm allowed 2 of those, and I'm going to call 2 friends today. I have Kyle King and Nick Church, who are both with the fiduciary section and can testify with some greater deal of authority than I can about the nature of the changes and can better answer any questions.
All right, I see no questions for the author right now, so we'll go to you, gentlemen.
All right.
Okay. All right. Thank you. I will. Yeah, I'm good. Thank you. I will be briefer than we were in drafting this bill. I understand y'all have other things on the agenda. So just generally speaking, this bill does a number of things. For one thing, it makes some changes in the banking code and the trust code to bring those into line with one another to make sure that the same standards are applying to individual and to institutional fiduciaries. Also makes some changes in the aspect of the probate code that deals with determining heirs. Frankly, the probate code is pretty sparse compared to what we have in Title 19 about determining paternity. And frankly, it shouldn't make any difference legally whether you're determining paternity during the father's lifetime for purposes of child support and things of that nature, or whether you're doing it after the father's passing to determine whether this child is a child who can inherit. So we've made some revisions in the probate code to take what's in Title 19 and import a good bit of that into the probate code so that the same standards are being applied. Also a number of changes to the trust code to deal with the fact that so many of the communications that occur between particularly institutional trustees and beneficiaries goes through email, goes through electronic portal, and of course we have adopted the Uniform Electronic Transactions Act 20 years ago, which is approximately the Pleistocene epoch when it comes to the development of technology. So this is designed to allow for that type of notification, communication relating to trust, except when it comes to creating a trust. You still have to have a wet ink signature to establish a trust. That isn't being changed, but it does allow for some of these communications to occur in a way that reflects the way we actually do business. And one thing that I don't know how many of you have heard about this, but I know Nick and I have been hearing about it consistently. The amendment to 53, or the creation of 5358, about notifying beneficiaries, that was adopted a couple of years ago, based on a very, very bad fact situation where there was an executor who was not doing the proper job, and the beneficiaries didn't know about it. And what we've tried to do is to follow the spirit of that statute, to clean up a few things with giving notice to people who already would have been notified, not having to duplicate that effort, but also, instead of it merely being something that if a person fails to do it, an executor fails to provide this notice, they, instead of just being cited to appear and possibly be fined, it's being made an affirmative duty to notify the beneficiaries, so that it actually has some teeth to it if someone is up to no good. And it extends the time period to 6 months to coincide with the period of time that an executor has to determine the condition of the estate and determine the debts, and be the point at which beneficiaries would be able to go to the probate court under 53762 and say, I want an accounting, I want my distribution, and as long as they get their notice in that time frame, they are in a position to execute their legal rights. So, Nick, I know I haven't covered everything, so I'm going to toss it over to you and let you fill in the blanks I left.
Kyle covered most of what I wanted to. Almost all the provisions in the bill have come to us from either practitioners around the state who have practiced law in this area and have run into trouble either in court or in their practice with certain aspects of it. And when that happens, we usually tell them to write up how they would want to change it, and the Code Revision Committee of the Fiduciary Law section considers those. So we almost, as I said, almost all of them are ones that have come sort of up from practitioners, which is a very effective way of seeing what needs to be revised. We have never thought we need any kind of wholesale revision of our probate code, trust code, or guardianship code since the work of those revision committees was done in 1998 and 2005 and 2010. So instead, really what we're doing is just trying to improve on what we already have, and Kyle mentioned a couple of those things. We did a lot of modernizing in 2018 and 2020 of the trust code, and introduced a lot of modern trust concepts that have been part of uniform laws or part of changes to the uniform trust code, and have brought those into Georgia code. So among the members of our committee are also fiduciary lawyers at some of the state's bank and trust companies, and I'm actually one of those now. I stopped practicing law at the end of last year and am now at Bessemer Trust, so I'm on the other side of this now in administering trusts under Georgia law. And as I said, we've always had members of the state's bank and trust companies on our committee as well who are practicing, and that's one of the main reasons why we have this new electronic trust transactions section that we are doing, which will allow most everything associated with administering trusts, other than, as Kyle said, the initial creation of a trust, to be done by electronic communication and electronic consent, including sending of reports and statements by electronic communication or on electronic portals. But with that, unless there are specific questions about some of the provisions in here, we'll leave it at that.
Mary Margaret?
Thank you, Mr. Chairman. Do you have a summary of this section by section prepared?
We do.
Yes.
Yeah.
I'm trying to follow what you said about changing the beneficiary law. And I'm also trying to follow where you may have changed compensation provisions. And forgive me for not being more prepared, but
No, it's a long bill. I
You're touching
understand.
on a lot of fairly
Yes.
central things, too. Tell me about exactly where you've, quote unquote, your term cleaned up the notice to beneficiary.
Okay, that is,
In the probate code.
yeah,
Okay.
that's
Floor Leader Wade's bill from about 2 or 3 years ago that I think we cleaned up a little last year.
There was an effort to last year. It passed the House and was favorably reported by the Senate committee and just didn't make it onto a rules calendar before
Did it
signing
fix it?
that.
Or have you incorporated that bill here?
We
or
have incorporated that bill
it-
here.
As it was written last year?
As it was written last year, yes.
Okay, where is it?
It is on page 50 of LC 48-1418, section 51 of the bill.
Okay, now tell me if you've changed where you've dealt with compensation provisions, because I was looking at a couple of them.
Okay, and I don't believe in this section at least we're dealing with compensation. We're just dealing with the notice to the beneficiaries of the appointment of the personal representative. And again, there's the requirement, instead of it, we've, again, moved some things around, but it's the personal representative has a duty to notify the beneficiaries.
Where are you reading from now?
I'm at page 50, section 51 of LC 48-1418.
I'm not sure we have any change to executor compensation or trustee
I don't believe we do.
compensation in this bill.
And if I said that in a way that made it sound like that, I apologize. But I don't believe there
I
are.
don't think we've touched those yet.
Kyle, is that still 2.5 in, 2.5 out?
It is, yes, sir. Yes, sir.
No, I don't think we've touched it.
I was just talking about it today.
I don't remember exactly what our fix was last year on the beneficiary notice thing.
Right.
But
It is, and I'm not going to swear to you that it is absolutely word for word what it was last year, but if it's not word for word, it's pretty close. But I think it's literally what was introduced last year.
And there's compensation language in section 54 on page 53 is one of the.
Okay. Okay, all right. So that's right. Section 53 on page 52, is that what you said? Just make sure
Section 54 on
54. 53, all right. My apologies. So what we're dealing with here, okay, you are correct, and I apologize. On the issue of personal representative compensation, it's a lot of it's cleaning up the language in there that it's if there is a written agreement entered into by the decedent and the personal representative prior to the decedent's death, or if there's a written agreement signed by all the beneficiaries who are affected by the compensation. And that's really the substantive change, is that right now every beneficiary of an estate would have to sign off on that. So if you have residuary beneficiaries, but you have a handful of people who are getting specific bequests of, grandpa's pocket watch or grandma's wedding dress, those beneficiaries would have to be involved in making decisions and signing off on the personal representative compensation. Since it would be paid out of the residue of the estate, it would be coming out of the shares of the residuary beneficiaries. So essentially, if your bequest, if what you get under the will isn't going to be affected by what the personal representative is being paid, you don't have to be involved in that decision. If it is going to take money out of your pocket, then you do have to be involved in that decision.
You're raising an issue that I had not previously thought about, and it implies, maybe under existing law and maybe under the way this changes it, that's what I'm puzzling about, is that the beneficiaries and the personal representative could get together and say your compensation is going to be 50% of the estate. That's allowable under the law now and allowable under the law under this.
In theory, it's allowable under the law now. Again, it would be, first and foremost, there's the statutory default. Secondly, you can specify in the will, here's how my executor will be compensated. Under existing law and
with no
under
caps and no protections in any way.
That is correct. That is correct.
And this doesn't change that, it just narrows the number of beneficiaries that have to agree in writing.
That is correct.
Okay. Thank you.
Thank you.
Any other questions for these gentlemen?
I'm just still trying to figure out what all's in this thing, Mr. Chairman. I'll just be honest.
It might help if y'all go through section by section.
I mean, it's a lot, and it's touching a lot of areas that I don't know anything about.
Various titles.
Yes.
I would like to have
you wanna give
Do, I mean,
a summary that I could review before I have to vote on something like this.
Do we want to lay on the table, or do you want us to go through it
I
today?
just don't know what's going on. You should talk DNA testing and paternity testing, and I see stuff like clearing, condensing, and we're talking about murders.
Well, let me ask you, would you rather a section by section now with these folks, or you want to table the bill and get a summary from them and compare that to the bill that you have?
It's whatever you want to do, Mr. Chairman. I'm just saying I want to, we're going to slow
Well,
down.
the summary, we have a summary, but it doesn't, it just
It just,
doesn't give you a lot of detail, because obviously if you, as much you give a lot of detail, you've got a summary that's as long as the bill itself. It does tell you what the generally is being done, so you could perhaps direct you to sections the will you want to
I
look
mean,
at.
I kind of feel like I want to hear what all it does and then have an opportunity to digest it before I have to vote on it. I mean, that's,
okay.
I would agree, Mr. Chairman.
I'm not trying to slow things down, but I'm just don't know what the heck's going on.
I apologize for not reading all this before.
I understand.
no, it's,
While I have these gentlemen here,
Yeah.
if you don't mind, can you go section by section in the bill?
yeah,
Yeah, we can start.
absolutely.
Yeah, I've got it. So as Representative said, we've got general descriptions of what the sections do, and I guess I can read that, Kyle, and if you want to add to any of those as we go through the pre-trust code sections, we can do that. Sections 1 through 6 amend Title 7. And these really are to harmonize just terminology in Title VII with changes that were made to the trust and probate codes since 1998 and in 2010. Cal, do you want to add any?
No, I think we're good. Again, unless there's any questions, we'll be happy to address anything specific.
Section 7 is an amendment to the Uniform Power of Attorney Act. As Kyle said, that was, or as Representative Lever said, that was adopted in 2017, amended in 2018. There were certain provisions in the Uniform Power of Attorney Act that are, which has a requirement for how a power of attorney is to be executed, and requires witness and notary so that they're accepted under that act. There are certain types of delegations of power or powers of attorney that have been accepted from that, just because they come up in other circumstances and don't need that kind of requirement. And we've been steadily adding to the list of those as practitioners have come up with ones that don't need to be covered by that. For example, an early one was when the corporate lawyer said, well, stock transfer power, this that you ordinarily transfer stock, usually has in it a mini power of attorney that says the officers of the company can move the stock on the books. That one didn't need to come under the Power of Attorney Act. This one that we're changing here relates to the delegation of powers by fiduciaries under will and trust instrument. That is sometimes done by a power of attorney, but it doesn't need to come under the provisions of the Uniform Power of Attorney Act.
Okay, now, well,
Do you want me to pause after each one? And
I want to ask the committee if you have questions as we go through this, turn on your microphone and then we'll go. What you got?
And so you're saying, thank you. Is this one working? Yes. Thank you. So you're saying that it's not working? Now it is.
There we
Okay.
go.
So you're saying that for trust and probate that this does still require a witness and a notary, or no?
It would not.
It would not.
Yeah,
Okay.
you would not have to do. You would not have to have a power of attorney executed that meets the requirements of the Uniform Power of Attorney Act in order to exercise one of those delegation powers under a trust.
Okay, thank you.
Will.
All right. Representative Hong.
Thank you, Chairman. And so, and this section is only dealing with when it comes to probate, will, or trust. It doesn't touch any other sections as far as power of attorney. And it's just allowing for a personal representative trustee or trustee that is provided in a will and trust instrument. Is that how, am I reading that correctly?
Right. If you look,
Okay.
it's 9. It's part of a long list of powers of attorney that don't have to meet the formalities of the Uniform Power of Attorney Act. And I came up with the stock transfer power one. What are the others?
We had some that were, well, there were issues with people setting up Medicaid-related trusts that, you know, if there wasn't a specific grant of powers, but that needed to be included in there because people obviously needed to set those up sometimes on the fly. So there've been a number of things, some related to real estate closings that again, they're already standard forms. But to your specific point, you are correct that this is only dealing with if the will or the trust instrument allows a delegation, then it can be done without complying with the Power of Attorney Act. Of course, anytime a fiduciary is delegating to someone else, the fiduciary is retaining the liability for that person failing to behave correctly. So there's already a pretty strong incentive to make some wise choices there or suffer the consequences.
Yeah, and Mr. Chairman, if I may just again to
Grab one of the mics.
reiterate what Nick just said, this is a section of the Uniform Power of Attorney Act. It basically says if you're going to sign a power of attorney after the effective date of the act, you got to use this format and you got to have it by this formality. And then there's some exceptions because there are a lot of other documents that you occasionally are asked to sign or have to sign in the course of other business and other personal matters where you're technically delegating authority to somebody else to do something for you, and those aren't always there's a statutory form of the Uniform Power of Attorney, and there's also certain formality requirements. I think you've got to have it witnessed and notarized, and these are just exceptions to that formatting and formality execution requirement. Things like when you sign a stock power, usually that's not witnessed and notarized, I don't think. And it's kind of got a power of attorney of a sort in it where you say, well, I authorize the officer of the company to move all this stuff over on the books. And this is another example. If you've got it doesn't really apply to wills, but it's when an authority an ability to delegate a power is given expressly in a will, and the holder of the power is going to delegate it. They don't have to use the Uniform Power of Attorney Act form or that formality.
All right, if y'all would continue then.
Section 8, it was mentioned that this only applies to the Uniform Power of Attorney Act. This is another amendment to that. Only applies to powers of attorney executed after a certain date. What this cleans up is the provision of the act that explains which provisions apply when and how the Uniform Power of Attorney Act and the pre-existing Power of Attorney section of the code apply to old powers of attorney. There was some ambiguity in how exactly that applied under the existing version of the act. And the intention was to have the Uniform Power of Attorney Act only apply to powers of attorney done after a certain date. All right, Section 9. Kyle, I'll let you do this one.
So 15.9.127 is the part of Article 6 that deals with probate courts with expanded jurisdiction, and these are powers that certain probate courts in counties with sufficiently large population have concurrent jurisdiction with the superior courts. Of course, in the superior court, the Civil Practice Act applies pretty much uniformly. In probate courts, the Civil Practice Act applies unless there are special rules relating to particular probate proceedings. And what this is specifying is that if you've got concurrent jurisdiction, if you go to the Superior Court, obviously you follow the Civil Practice Act. If you're doing this in the probate court, then notice, summons, process may be done using the provisions of Title 53 that normally apply to probate courts. So it's just clarifying when it does and does not apply. And again, that's a may. Doesn't mean the Civil Practice Act won't work. It just means you can use the standard probate court procedures as well.
You keep going now that we're in the guardianship.
Okay. All right. So,
code.
yeah, beginning with Section 10, this will cover through. How far does that go?
17.
Okay. So 10 through 17, these are changes in Title 19 that deal with a couple of things. Number one, again, bringing things into line with one another to make sure that the section of Title 53 that deals with heirship determinations and the provisions of Title 19 that deal with paternity determinations are following the same procedure. This, and I apologize for overlooking this, I'm glad we're going through it because this is important. As the members of this committee undoubtedly know, the General Assembly enacted legislation, I think in the 60s, but many, many years ago in any case, dealing with artificial insemination, which at the time was the accepted medical terminology. Since then, we have developed other methods. I say we like I had something to do with it. The medical field has developed other methods like in vitro fertilization, and the Court of Appeals has interpreted the old language to mean since the General Assembly hasn't added in vitro fertilization or other forms of assisted reproduction, then those things are not included in the terms of artificial insemination. And of course, as is the case a little more often than any of us would like, what the Court of Appeals believes the General Assembly intended may not line up with what the General Assembly actually intended. And so what this is designed to do is to show that if you're using assisted reproduction by whatever means, by whatever name, then that applies, whether it's artificial insemination or in vitro fertilization. So that, again, covers Section 10, Section 11, and then further in there, Sections 12 and 13, dealing with the effect of determinations under Title 53, again, after the putative father has passed away. Section 14, again, continues the in vitro fertilization just being added essentially everywhere that it refers to artificial insemination in the code. Same with Section 15. Section 16, again, is lining up the provisions of Title 19 with Title 53. Again, it's two different timetables, it's two different situations. So it's one is not impinging the jurisdiction of the other within their sphere. Section 17 again repeats that for the Uniform Interstate Family Support Act. Section 18 is a little bit of cleanup. It talks about beneficiary such person. Of course, it's a person's estate rather than that individual. Made references to conservators and guardians. We're using some, I won't say archaic, but language that has been around for a while, like incompetent, that normally does not line up with some of the terminology that we use today. Furthermore, just clarifying, if you're going to tell somebody the time and place, you tell them the date. And my own commitment to grammatical exactitude, you will notice a lot of whiches being replaced with that and that sort of thing. Section 19 is something that we missed a few years ago. It was the limit, and this is under provisions like 2933 and similar provisions of the Guardianship Code, that the $15,000 cap on what a natural guardian, a parent, could receive on behalf of a minor child without becoming the official conservator. That had been bumped up to $25,000. We thought everywhere in the code, but it turned out it had been missed, and I have to thank Judge Sarah Harris of Bibb County for pointing this out to us, that it was, in this particular case, it was left at $15,000, so this is increasing it to $25,000 for judges of probate courts being custodians of certain funds, so that it lines up the same number across the board. Section 20 is just incorporating, changing a sentence fragment into part of the actual sentence it was intended to be part of. Section 21 continues the changes regarding in vitro fertilization, and while we were there, you'll see on line 446, it talks about when a child is born on a moving conveyance and is first removed in this state, the birth shall be registered in this state and the place where it is first removed. Figured we might want to specify the child rather than referring to children as it. Section 22, again, is clarifying the language that the Court of Appeals has read in a very narrow fashion. Section 23 deals with an old citation. I'm not sure how old this is. It probably goes back before 1998, but it is, those code sections are not in the code any longer, and so it's replacing them with the proper provisions as they now stand. Then we get into the next series of sections, 24 through 27. This is dealing with the uniform statutory rule against perpetuities. Everyone here who ever went to law school can groan. I understand this is no one's favorite topic. We're simply bringing this into line with recent changes to the trust code, and that's all we really need to say about that.
Yeah, that got comprehensively revised years ago, but those are changes that are made to, as Kyle said, to coordinate this with the trust code better, and with changes that have been made to the trust code since the rule against perpetuities, which still does apply, even though it's now a 360-year rule instead of a 90-year rule.
Yeah. Everybody wants to run away from this one.
No, I know.
I understand.
Quickly move on.
Yes.
I was going to say, had enough yet, Mr.
Yeah.
We're getting to the better stuff now.
Yeah. So sections 28 through 30 are dealing with, and again, there are a lot of uniform acts here. The Uniform Prudent Management of Institutional Funds Act. The Uniform Law Commission, rather, is continuing to produce new uniform acts. Georgia has not adopted a lot of these because Georgia has had its own body of trust law codified for a number of years, whereas a lot of states didn't. But whenever these new acts come out, we look and see what makes sense to incorporate into what we already have. And so this is bringing our version of the Uniform Prudent Investment Act into line with certain provisions of the Uniform Prudent Management of Institutional Funds Act.
Yeah, or vice versa, because we made a few changes in 2020 to the Uniform Prudent Investment Act, and both, which applies to trusts mainly, but the Prudent Management of Institutional Funds Act applies to charities, but we're making the investment provisions of that act that applies to charities match what's in the act that applies to trusts, where it makes sense to have those match, which helps those that administer institutional funds at charities and those that manage institutional funds of trust know they have a similar set of fiduciary rules that apply to investments.
All right, 31 is in the provisions of the code relating to torts, and it's again dealing with children born out of wedlock, and bringing that into line with what's in the probate code, so that in those situations, if you could inherit, you can receive a share of a tort settlement.
Okay, let's
Torts, Mr. Chairman, let's say wrongful death.
Wrongful death. Thank you. I apologize.
All right,
I'm sorry.
let's
Not
hold
trying
that.
to get us into something else.
We've got a question.
Thank you,
Representative Kelly, go ahead.
Thank you, Mr. Chairman. I read slower than I talk, and so I'm a couple sections behind.
That's all right.
Can we go back to line 614 and help me understand the purpose of that language and what it does?
Yeah. So the language from 614 to 619 relating to investing institutional funds, this is taken out of the existing language that's in the trust code now. There was This is an interesting provision, and Georgia's a little different from a lot of states in the way we did this provision. There were some states years ago that in their trust codes adopted the so-called ESG type language, environment, social, and governance language, to allow trustees to invest in according to ESG principles if their beneficiaries wanted them to. When that came here, and when our code revision committee considered those kind of provisions, we saw, maybe sooner than was generally people generally became aware, that ESG would often be very political, and that so to avoid that, rather than just having an ESG provision, we made it clear that trustees could invest to take into account their beneficiaries' wishes with regard to not just environmental social governance, but social, political, religious, philosophical, environmental governance, in other words, the full gamut of principles that may apply to investing. So for example, someone may have, and now what we're doing is taking that language that we did in the trust code, which we think has worked fairly well and is kept from being political, into the Institutional Funds Act so that it applies to charities as well. And to give you an example, you might have a charity that is a religious organization whose religious body has set certain investment principles, and this would allow them to invest in accordance with those, what they view as religious principles that govern investment for the investments they make in the charity. That may be very different from what another religious institution or a non-religious institution might adopt with regard to its investment strategies. They might have ones that go to other philosophical or other political or other social ideas. But what this does is allows a charity in exercising its fiduciary responsibilities over investment, just like we've authorized trustees in managing their fiduciary responsibility with regard to investment, to take those into account without that being deemed to violate their fiduciary obligations.
Okay. Thank you for the explanation.
I still got you on a live mic. I didn't know if you wanted.
I'll let them keep going.
All right.
All right, thank you.
Where were we?
I believe we were at section 32, which is on page 27. And this, I know y'all love having us, but in the hope of us not having to come back and do this as often as maybe we do, the language in 5319 that already makes it clear that the common law and principles of equity, continue to remain the law of this state. Want to add a little bit of language to toughen that up and just say that, if we're codifying something, it doesn't mean that principles of the common law that haven't been codified aren't still the law, and that there's no implication that the common law didn't provide for that. The idea being that we worry about when we put things into the code, are we creating a situation where the Court of Appeals or the Supreme Court is going to look at stuff that wasn't codified and say, well, if they put some of it into the statute and not all of it into the statute, then maybe the old stuff doesn't still apply, and so these bills are not even longer. We're hoping that will help put some signposts down for the courts to follow.
All right, I got another question here.
Yes, sir.
Representative Oliver.
I'm also backing up to section 31.
Yes.
I just pulled out 5323, and I'm trying to understand your language on lines 656 and 657. The first sentence, beginning of paragraph F, is very clear, and then you're saying in 56 to 58, 656 to 658, that it's controlled by 5223. Tell me where a child born out of a wedlock is not an heir. Does anything in 5223 say that a child born out of wedlock is not an heir?
Well, a child born out of wedlock, it does say, in fact, we've got revisions to it in section 34, but what it says is under paragraph 2A, a child born out of wedlock may not inherit from or through the child's father, the other children of the father, or any paternal kin by reason of paternal kinship unless, and then there are a series of qualifications that again are trying to line this up with what's already in place under Title 19 to make sure that, frankly, people who are heirs are inheriting where they should. But it is there is an exception that is created under the existing code.
And what is that exception? That a child born out of wedlock is not an heir. What is the exception?
Well, again, it's a child under 5323(2)A A child born out of wedlock may not inherit from or through the child's father, the other children of the father, or any paternal kin by reason of the paternal kinship, unless any of the court orders have been issued, or there's other evidence. Father's executed a sworn statement. Again, we create certain presumptions, or there's other clear and convincing evidence. So
it's a proof standard set out in 52.3. It's not a categorical denial, it's a proof standard.
Yes.
Yes.
Thank you.
And that what Kyle was saying is that proof standard now, and you'll see this when he gets to section 34, which I guess he's about to.
Yeah.
The proof standard that has long been in the guardianship code, and that also applies to that is applied in those sections, are now being imported into the probate court so that they match.
But it all relates to proof and not category.
Oh, right. Yes. The category question was decided.
That's what I was confused about.
Yeah.
Thank you.
Quick question, does it include DNA evidence?
Yes.
Like Kyle,
Yes.
he's got a lot to get into that. Yeah.
And the short answer, and we'll get into the specifics, but the short answer is that, again, in Title 19, it's very specific about DNA testing and what the standards are.
Okay,
and
great.
in the probate code, currently, they are much more amorphous and much more general. And so essentially what we're doing in many of these sections is taking what's there in Title 19 that's specific. For instance, it's got to be accredited by the American Association of Blood Banks, or that type of thing that's just not in the probate code and frankly needs to be.
You have helpfully clarified for me that a child born out of wedlock is an heir. You just have to prove they're an heir.
Yes. Yes, that is a fair way of putting it. Yes.
Thank you.
All right, beginning in section 33, again, because we're bringing some stuff in from Title 19 to Title 53, obviously we're making it clear that this does not give probate courts any authority over Title 19 that belongs in the Superior Court. Section 34 is the revision to 53.2.3, again, goes into a fair amount of detail, just clarifying because there are a lot of different types of orders regarding child support, determinations of paternity, etc. And again, going all the way through here, there are some things that, for instance, it refers to, currently in the code, if a father has signed a birth certificate of a child. Which sounds well and good, but we don't actually sign birth certificates. So that is not really providing anything, and so we've again augmented that to talk about if the father has consented to have his name and social security number appear on the birth certificate of the child, for instance, or acknowledge paternity in a way that would be sufficient under the various provisions of the code, including what's there under Title 19. So to your point, Representative Oliver, what we're doing is clarifying that proof that's good enough under Title 19 while the father's alive will be good enough under Title 53 after the father is deceased if that hasn't been resolved during the father's lifetime.
And so you see there's a lot of references to Title 19 in here. Originally we had repeated a lot of the language in Title 19 just again into this, and it was Professor Radford, I think, that suggested to Kyle that he do that through these references and strip this down so that it's actually much shorter.
This actually is a short version,
believe it or not, than what it originally started at because of all the, in other words, and that will actually make it easier to modify in the future because you can concentrate on the Title 19 where it comes up much more often than in Title 53.
Section 35.
Hey, hold on just a
yes,
second.
sir. I'm sorry.
Representative Reeves.
And it took a while for her to get mentioned, but did I hear that Professor Radford has reviewed this bill?
She has looked at this bill.
Yes, thank you.
She says she is out of the legislation drafting business,
But we
but
don't
whenever
want
when we put together a draft, we send it to her. She marks it up in red ink and sends it back to us. And yes, this has many of Professor Radford's fingerprints on it. All right, Section 35 is dealing with inheritance by child born out of wedlock from the maternal side. Again, dealing with some of the same issues. Obviously, the nature of human reproduction being what it is, it's a lot easier to determine if someone's a child's mother than if it's someone's a child's father. So that one's a little bit shorter code section. The following code sections under, Section 36, deals with, again, cleaning up the language on artificial insemination and making it clear that, what prevails in terms of conflicts between Title 53 and Title 19, again, because it comes up more often in Title 19. If there's any conflict, Title 19 is going to control. We don't want to mess with an established body of law there. 5329 is just because we want to make sure that it's clear. We have the definition of the term child born out of wedlock in Title 19. That same definition is going to apply in Title 53. All right, then we...
From 38 all the way
38.
to Section 46, I
Thank
think.
you. Yeah, 38 and 46 continues along the airship determination. Again, I'll be happy to go through specifics, but the general gist of it is importing these concepts from Title 19 so that they are lining up under Title 53, and obviously making sure that when we do that, we're not implying that the probate courts can do anything that they couldn't do previously. They're not obviously going to be dealing with child support and issues along those lines. Some of these provisions deal with how to go through a process in probate court or in superior court. So there's some language such as, for instance, in Section 44, dealing with how it goes in the probate court as opposed to how it goes in the superior court. Section 45, again, deals with the DNA testing issue that is much more strongly and robustly spelled out in detail in the code concerning in Title 19 than it is in Title 53. So we're bringing a lot of that in, which again covers same with Section 46 is dealing with, again, the difference between whether we're proceeding in a probate court or in a superior court. Section 47 brings in
This is now the guardian.
issue from 5311-2 in terms of who represents unrepresented estates, guardians ad litem, and things of that nature. And then we again have for service under Section 48, the different provisions for serving anyone, and obviously authorizing the probate court or the superior court to direct additional service as necessary to make sure that anybody who needs to get notice gets notice.
Those relate to the escheat provisions, and that's just a cleanup on procedure.
All right, well, Nick, do you want to
Sure, I can.
49?
Yeah. 53.4.5. Now we are into the section of the probate code that is relates to the wills and administrations of estates. Section 53.4.5. Years ago, we added the ability to dispose of tangible personal property through a separate list that could be signed and dated. It has been very popular from what I understand, and what we are just making clear in this is that that written statement that meets those requirements isn't deemed to be part of the will. The probate courts have all differed on whether or not they consider it a part of the will that needs to be filed with the rest of the will, that needs to be included in what is given to the heirs and that. And so this just clarifies that it's more like a document incorporated by reference than it is the actual testator's will. Section 50. During the pandemic, the governor issued an executive order, and the fiduciary law section had some input into that when it was done, that basically said that for purposes of the 400-year-old statute of frauds, presence, which you have to execute and witness a will in the testator's presence, included doing it by video through Zoom where everyone could see one another. It was never totally clear whether the governor's emergency powers extended to amending the statute of frauds like that. And so what we've done is essentially said that if you executed it pursuant to that order, that the will's not going to be treated as invalid solely because it was not executed and witnessed in the testator's physical presence. Frankly, we're surprised we got this long without a court case on that. We worried about it from the very first moment, but hopefully this will and we know of no current court case that we might be affecting through this section, but this is just to give some comfort to those that use those provisions and still have not gotten around to maybe they can't have gotten around to executing the will with physical presence of witnesses.
All right, we have a question.
Okay.
Mr. Jurek, does the probate community have a term for the COVID protocol? I know some in the real estate community called it remote in-person notary, I think. Is there a similar term in the probate community for what y'all did during COVID?
I don't think
there is
so.
one.
It was just it just allowed for remote witnessing of
FaceTime
the
or
will.
Zoom.
Right,
Yeah,
Zoom or
okay.
FaceTime. And there was a set of what were they called? Recommended procedures
sort of
that the
best
fiduciary law
practices.
best
Yes.
practices that the fiduciary law section issued at about the same time. Fortunately, that period didn't last too long before we were able to do it in physical presence again. Okay, section 51. This is the provision that Kyle talked about earlier. This is the amendment to that notice of beneficiaries provision. It had formerly required notice within 30 days by an executor of all the beneficiaries of a will, and then the requirement to file those notices with the probate court. It, from the start, just has caused a lot of issues. Sometimes that's a little too soon for an executor to want to be notifying beneficiaries, not for any nefarious reason, but just for a good management of the administration of the estate. So, but we did acknowledge with the sponsors of that legislation that there was a bit of a absence in our probate code. There was no explicit requirement that a executor ever had to give notice to beneficiaries. It makes sense they eventually have to, because if you're going to administer an estate, you have to eventually give the property to the beneficiaries of the estate. So it just was sort of in the logic of administration of the estate that beneficiaries would eventually get notice. But acknowledging that there may be a gap there, we thought we would tie it to, first of all, to strengthen it in a sense by making it a duty rather than just a procedural requirement and something that has to be filed, where the only remedy is losing your letters testamentary as executor. This is a duty that you could actually be sued under now if you didn't comply. So that strengthens it. But then we tied it into the 6-month period that an executor normally has to marshal assets of the estate before they have to start dealing with creditors. And so we thought we'd put beneficiaries in that category as well and give them that 6-month period before they started having to deal with beneficiaries.
All right, I have a question for you.
Thank you, Mr. Chairman. I appreciate the work y'all are doing on this. I've seen this come up in my practice several times, and I don't know if there's still anyone here from the probate judges, but I've been curious if they were going to work a standardized form in for this. Do you know, because I mean right now I've seen different probate courts handle it different ways as to how you can, if you're an heir and a beneficiary, it's easy to acknowledge and waive, right? That's there, but we don't have a real form for someone who's a non-heir beneficiary to acknowledge and waive.
And by making this change, we've eliminated the need to file anything. So there won't be a need for a form.
Okay, you just
You'll
have to do it.
You have to do it. And so you can later be essentially sued for not doing it within it. But there's we've eliminated the procedural need of filing it with the probate courts.
Okay, thank you.
The probate courts have been all over the map, and most of them got them and they don't do anything with them. Some added to a checklist of things you have to do. And so we thought there really isn't a need for it if we've made it a duty of the executor, like the duty of with all the other duties they have in administering an estate. I think the probate judges should be okay with it. In fact, they have been in those that we've run this by. That was section 51. Again, that passed unanimously in the House last session and was favorably reported by the Senate, but just didn't make it on a rules calendar. 52, section 52 and section 53, again, are just provisions that harmonize the banking laws with provisions of the probate, harmonize provisions of the probate code with provisions from the banking law. Really adding some cross-references. Section 54. This amendment, as well as amendments to sections 53.768, which appear in section 60 of the bill, and 53.769.1, which appear in section 61 of this bill, goes to what we were talking with Representative Oliver earlier about, are who are the beneficiaries that have to consent or get notice of certain things in administering a estate. And it is to deal with the beneficiaries who are not the residuary beneficiaries, the ones that are actually affected by the distribution of the estate, but might be just a beneficiary of, a single item of personal property, or just $1,000, to my aunt, for example. Those are beneficiaries who don't really have a stake in some of the questions that are dealt with in section 60 and sections 68 and 69.1. So this one is who has to consent to the compensation. And then when we get to the later ones in section 60 and 61 of the bill, it's who has to consent to the filing and mailing of returns that are provided to heirs and beneficiaries, and who has to consent, and the provisions relating to the provision of annual statements to heirs and beneficiaries. Those are not the beneficiaries that really need to get all that, because their interest is usually very well defined, and they either got it or they didn't get it. We toyed with different ways of defining this group of beneficiaries, but in this one you see it's the ones affected by the personal representative's compensation, and we've done it a little differently in the other ones, but we'll get to those.
Sorry, what section?
Right now we're in section 54, and the sort of parallel sections are 60 and 61 of the bill. All right, section 55. This is another amendment that harmonizes the provision that we added a few years ago that provides for a guardian ad litem to represent the estate of a deceased beneficiary or heir in doing a probate. You sometimes get successive estates within a probate, and this allows the court to appoint a representative for that estate rather than requiring an entire probate proceeding for the estate of a deceased beneficiary. Section 56 is another one of those. This removes the requirement for a delegation. This is the parallel to the other provision we talked about in the Uniform Power of Attorney Act that no longer requires a delegation under a will to be satisfy the requirements of the Uniform Power of Attorney Act. Originally, when the Uniform Power of Attorney Act was drafted, this provision had been written to say that it did have to meet the requirement, and that was later made very aware by practitioners that was not. That was impractical and also not a good use of the Uniform Power of Attorney Act. So this is the parallel to that. All right, section 57 clarifies procedures for relieving the personal representative of their duty to make an inventory. If I just really clean up language. Section 58. That, I think, is just some cleanup of grammar.
Okay.
While we were there. Some of which Legislative Council spots too when they go through it and revise our bills. Section 59. Go ahead. Yep.
And I don't practice in this area, but the 1432, line 1432, I know you inserted in a timely manner. Is there a time period? What's a timely manner?
And it's covered earlier in the code section that's not being changed, but essentially the way it works is the personal representative within 60 days of being appointed, has to run a notice to creditors in the legal advertisements for 4 weeks, and then any creditors have 3 months from the final publication date to produce their demands for payment. This is not an actual substantive change to the law. It is frankly an example of my OCD and my unwillingness to accept any split infinitive unless it's uttered by Captain Kirk. And we originally wrote it as timely to notify, and the Code Revision Commission resplit our unsplit infinitive. So in order to avoid going back and forth with them, we're just adding in a timely manner and moving it to the end so that we don't have to have this argument. You don't have to hear from us every other year when we want to go back and fix it.
Oh. All right.
Section 59, this is an amendment to the provision about discharge of personal representatives. That's again, it's another one of those provisions where beneficiaries have to consent to that, and there's some just cleanup of language, but also a provision about again, the estates of deceased heirs and beneficiaries being able to be represented by that guardian ad litem under that new procedure that we adopted a few years ago. Sections 60 and 61, these are the ones I referred to earlier, where we are making it much clearer exactly which beneficiaries have to get, or have to, in this case, in section 60, it relates to the filing and mailing of returns that go to heirs and beneficiaries, and then in 61, the provision of annual statements to beneficiaries. The reason we've given some concentrated attention to these two sections and have done a lot of changes to it is because these are important sections in the administration of an estate. And it is, the language that exists in the code is just not very precise and very clear about which of these heirs and beneficiaries are supposed to get the notice and exactly how, the annual reports and the what are called returns. Yep. And
the annual if you're not getting an annual return formally, just a statement of receipts and disbursements, essentially a spreadsheet. And it really ties in with 53.5.8 and it being a duty that if you have an interest that can be affected by how the personal representative is administering the estate, then you need to be one of the people who gets copies of these statements, or is you would have to be someone who consented to not getting them if you chose to do that.
Very often in a will, the requirement to provide these kinds of returns and sometimes even annual statements is waived, but where these will apply is in the case of an intestate estate. And so the provisions regarding heirs, which we've made match what would go to beneficiaries under a will, are really, in a way, the more important ones here, because those, although those can also be waived through application to the court, they're very often not, and so they will apply in those circumstances. All right. Let's see. Section 62. Is just cleanup and a clarification of who those, what those means in that sentence. All right, section 63, we're now in the trust code, which is 53, chapter 12 of 53. So all of the trust code provisions will start with 53.12. And so some of these get pretty technical. In 53.12.2, we have added a new term, donor, to the code. The code has existing term, settlor, which is usually thought of as the creator of a trust. But often the creator of a trust is not the same as those who might later make contributions to that trust. And so what we've done here is defined a new term, donor, to capture those who actually contribute property to the trust. And then we went through the trust code, and instead of using the term settlor or any other term, where the provision was designed to protect some kind of treatment of the donor for tax purposes or creditor protection purposes or whatever. If what was important was not so much the person who created the trust, but a person who actually contributed property to the trust, we changed that term then to donor, so that we could specifically distinguish between those who give to a trust versus the person that may have created the trust. So the first section, and I'm glad it comes first, is in the definition sections to create that term donor. And then you will see, as we go through these trust code provisions, you'll see some changes to use that word donor where it is important to have used that term donor. Also, in this definition section, we have we've attempted to clarify the representation provisions as it applies to charitable trusts, where the Attorney General usually has the rights of a beneficiary when it is the kind of charitable trust that doesn't have defined charitable organizations as beneficiaries, but rather just a class of unascertainable charitable beneficiaries. And then sometimes you can have trusts that are a mix of a private trust with individual beneficiaries and also charitable beneficiaries, and this is to clarify. We made some changes years ago to make it clear when the Attorney General comes in, but rather than the simple statement that's in there now, we've made it a little more explicit about when the Attorney General has those rights. Right, and then there's a change to the definition of trust instrument. More and more trust instruments are modified or subject to non-judicial settlement agreements that amount to modifications, and so we want to make clear what trust instrument means in this code is not only the original agreement, but all of these other court orders and non-judicial settlement agreements and the like that amend that trust instrument.
Okay, I've got a question for you.
Okay.
Representative Holcomb.
Thank you. Hi, Nick. It's good to see you again. On section 63, can you just, I understand what it says, but can you give us a concrete example that would be implicated with the Attorney General with this new role? I want to just conceptualize it.
So you will sometimes have a trust that will allow a distribution. It won't say, for example, income can be distributed to, say, the First Baptist Church. It will say can be distributed to any one or more charitable organizations selected in the discretion of the trustee. And it may have, that may come at the end of a trust, for example, that has individual beneficiaries who may be getting the income of that trust during their lifetime. So you've got what we call a mixed trust. So in those circumstances, there are sections of the code that specifically relate to charitable trust, and they're almost treated just like charities if they're wholly for charitable organizations. But you may have a trust like the one I just described that's a mixed trust. And in some mixed trusts, you will have private individuals as beneficiaries and then named charitable organizations as a beneficiary. For those, we want to make it clear the charitable organization can represent themselves as a beneficiary, and the private individuals can be represented the way they are in trust, and that trust can be subject to the general trust rules that apply to any trust, not to the ones that apply just to a trust that's wholly charitable. But Ed, if you do have that language that leaves it up to the trustee's discretion, one or more, any kind of charitable organization, at that point, there is no charity that can represent itself. At that point, you do need the Attorney General to come in. But the provisions that have applied to the Attorney General coming in really, in the past, before we made these changes, really only applied to those wholly charitable trusts. But this will now allow them to be essentially the representative of those unascertained charitable beneficiaries when we do the kind of things with trusts that we do under the code that aren't relying on those charitable trust sections. They're relying really on the private trust sections. But it allows them to be represented.
Okay, thank you.
I hope that helped.
Okay. All right, continue.
All right, section 64. This is the counterpart to the provision that Kyle described earlier about the common law. In fact, it's pretty much word for word of the one.
That's section 32 is the one in the
Yeah.
probate code. This is the corresponding provision in the trust code.
And just makes it clear that the whole trust code was written against the backdrop of the common law and equity that governs trusts. And just the fact that you've codified something in the trust code doesn't mean that you've rejected any kind of former principle of common law, or that principle of common law didn't exist until it was codified. That's another one with Professor Radford. She debated whether we should even do this because it's sort of stating what the law is. But I think Georgia has, in our area in particular too, has been a victim of the fact that Georgia codified the law very early. You know, in the 1860s, Georgia codified and purported to codify the entire common law as well. And I think as a result of that, we are a very codification-minded state. And when you don't see it in the code, you tend to think it wasn't part of the common law. But that's really not the case. And we've seen that come up in some cases.
Or it's been preempted in some manner.
Or that
codification.
Sure.
Correct.
Right. Yeah, if it's been preempted, right.
And that's not the case. Whereas states that for years, until the Uniform Trust Code came about in 2010, many states had no trust code at all. They just had the common law of trusts as courts had developed it. And Georgia was one of the models for the Uniform Trust Code when it was created because we had codified it 160 some odd years ago. So this really doesn't change what the law is. And again, some of us feared putting it in because then now this seems like it might be a change in the law, but it's not. 65. Again, these are some of the change. This is an example of a change where we changed settler to donor because it is the provision related to a donor and not necessarily the creator of the trust. We also incorporate the definition of qualified beneficiary into this section as well. And let me see. And this is, again, the representation section. This is where someone represents the interest of a beneficiary in matters relating to the trust. This has been a very popular section. Until 2018, the trust code simply said parents can represent the interests of their children in any matter related to a trust. And what we did in 2018 was expand it to be what was in the Uniform Trust Code, which has a host of provisions that allow others to represent the interests of beneficiaries in the trust. And that representation is the fuel that has helped do a lot of the modern trust modification and other trust-related provisions that we've got in our code. They are greatly enhanced by our representation provision. And so we've been tinkering with it since then to enhance it even more. And in the section M that's added there on page 66, we make it clear that representation under this code section not only applies to provisions of the trust code, but also apply anytime there's a matter in the trust itself involving a trust that may require the consent of certain persons, or that you can use these representation provisions in exercising those provisions as well. So that this has been a really welcome section of the code for administering trusts, and we're hopefully making it even better. All right. Section 66. This amends 5312.9, which has been our also very successful non-judicial settlement agreement provision of the trust code. This allows, by agreement among the interested parties, to do what previously would have, in many cases, required a judicial order to do. And so that has allowed us to do a lot with the administration and modification of trust by private agreement among all those affected what we used to do, or used to have to go to court to do. We are clarifying in these provisions about when you can do a non-judicial settlement while the settlor is still alive. The ability to do that is limited when the settlor is alive, because when the settlor when his consent, his or her consent is required to do something with the trust, we worry about him retaining some kind of interest over an irrevocable trust that can cause tax problems, that it can cause the property in the trust to still be considered as owned by that settlor. And so for that reason, we still do require court approval for modifications of trusts and not non-judicial settlement. But what we want to clarify here is that it's only a certain class of those court-approved modifications that still require court approval. Anything else, even while the settlor is alive, can still be done by this non-judicial settlement agreement. And we've tinkered with this provision before, but it still was the most asked about question among practitioners of all the changes we made in 2018 was exactly how this provision worked with regard to trust when a settlor is still alive. And so hopefully we finally have got language here that will eliminate those questions. All right, 53-12-22. This looks like we are striking a entire section of the code. What we're really doing is separating language about interiorum provisions, which is another name for a no contest provision in trust. We're separating it into its own section 53-12-9, which you'll see in the next section, section 68. The fact that these provisions were together about the trust may be created for any lawful purpose, and then the interiorum provisions were in the same section, caused the Court of Appeals a lot of confusion in a case. And so what we're doing is separating them so that we've got each of those in their own section and they don't seem to be related. We are not, however, changing the law that applies to interiorum no contest provisions in trust instruments. We literally are just separating them into two code sections to avoid any future confusion. Section 69. We are increasingly seeing the use of revocable trusts in Georgia as a way of both disposing of property at death, but also managing property during the lifetime of someone when they become incapacitated. And revocable trusts were not typically used in Georgia as substitutes for wills traditionally, so we don't have a lot of well-developed statutory law with regard to revocable trusts. And so what we're trying to do is, as questions come up over time, we are adding some provisions related to that. This one makes it clear that when you have a revocable trust where a settlor can revoke it at any time and take the property back as if it was their own property, that the trustee's duties then should only apply to that settlor. The problem comes, and not to remainder beneficiaries, because those could be eliminated just by the settlor revoking the trust, which they could do just by saying to their trustee, I'm revoking this trust. The problem is when a settlor becomes incapacitated, then you really do want the trustee to potentially owe duties to not just the settlor, but possible other beneficiaries of the trust. Or you at least want someone to be able to enforce the trust so that they are treating the settlor right, because by definition now you've got an incapacitated settlor, and if he's the only one who has an interest in the trust, that means he or she's the only one that can enforce the trust, but he or she can't because they're incapacitated. So what we've attempted here is to strike a balance by making it clear that the duties are only owed by the settlor, but providing a mechanism for the duties for the trust to be enforced by those who have the settlor's interests, best interests at heart. And again, we've tried to strike a balance there between providing too many people with the ability to enforce that trust when they and the risk that some of them might be doing it contrary to the settlor's interests. And so on page 70 of the bill, you'll see some procedures there for the court basically to be able to ascertain that it really is the settlor's interests that are being enforced there, and not the interests of those that are really seeking to enforce it. Okay, that's section 69. Section 70. This is one of the provisions in here is a fairly technical provision. I mentioned to you that in the modification of a trust, when you have the settlor involved, you are worried about having the settlor involved and being treated as owning the property for tax purposes. The tax law has a provision that allows that if all the beneficiaries are represented. And what we're concerned with is that we can do certain modifications only requiring the qualified beneficiaries of a trust to participate rather than all beneficiaries. And to make sure, though, that we're still safe under that tax rule, we just wanted to make it clear that when the qualified beneficiaries consent, they are in a sense representing all the beneficiaries of the trust, so that there's no argument that any beneficiaries are being left unrepresented for that purpose. I think that's mainly what section 70 is doing. Section 71, this is the provision 531262 that was added in 2018 as part of the modernization and has also been very popular. Georgia has always, under its common law, allowed a trustee that has full discretionary power to distribute to a beneficiary to not only distribute outright to that beneficiary, but to be able to distribute it in trust for that beneficiary. I mean, sometimes that's called decanting of a trust. The metaphor being to decanting wine out of one bottle into another bottle. You're doing it from one trust into another trust. In 2018, we codified decanting so that trustees had a statute they could rely on as well. And that has been a popular statute. And really what we're doing here is just modernizing some of the language in it, clarifying some of the procedures, and replacing the term invade the principle, which we took from some older law, and just referring to distribute, which is the more modern term, and clarifying whose law, what kind of Georgia law needs to govern the trust before you can use our statutory decanting procedure. Before, it was only trusts where the substantive law of the trust was governed by Georgia. Now we're going to allow it to be done if Georgia law governs the procedure of the trust. So you might have a trust that's governed by the law of another state but is being administered here in Georgia by Georgia trustees. This allows those Georgia trustees to be able to use our decanting statute as well, and that matches what most trusts decided to do. Okay, section 72, 73, 74, and 75. These are all provisions of the creditor provisions of the trust code that explain what kind of access a creditor has to a trust. There are various provisions that refer to what a settlor does or what powers a settlor has, and these you'll see have all been changed to donor, and that's because these provisions about what access a creditor has to property in a trust are dependent on who gave that property to the trust rather than who was the creator of that original trust. And that's why we've used our definition of donor in all of these sections. So this is what's implementing, in a sense, that new definition of donor as distinct from settlor. 76. This is, I mentioned, the provisions of a charitable trust that are treated almost like charities. This is the cypre provision, which is the ability to modify a charitable trust. We have, this is the first time this language has been cleared up. It it only applies to wholly charitable trusts now, and this is just modernizing the language so that it's very clear how that cypre language applies to charitable trusts. All right, 5312-200 is another adding of a cross-reference to the banking code, just to make sure those are harmonized. 5312-201. This is new. Georgia's current law on filling vacancies, when vacancies happen in trustees, needed some modernizing and cleaning up, and so we have done that here. This goes along with the next section, section 79, which is the provision on removal of a trustee. Our provision on removal allowed removal of a trustee by petition to a court only by a person showing good cause. And there's been lots of litigation in Georgia about what good cause means, and it can often result in just fighting about what good cause. What we've added here are provisions that were taken from the Uniform Trust Code and the trust code in some other states where it seems to have worked well, that increases the ability of beneficiaries essentially to remove a trustee. Increases the grounds on which a court can do it and makes those a little clearer than just good cause. But also allows removal of a trustee by all qualified beneficiaries if that court then finds that that is in the best interest of all the beneficiaries and isn't inconsistent with a material purpose of the trust. Because often there can be material purpose reasons why a settlor named particular trustees to be trustee of the trust, and just because the beneficiaries don't like them, if those trustees are part of the material purpose for creating the trust, it's important to still enforce those, and those would be still enforced. All right. 50. Yep.
Representative Kelly.
Now, is that anywhere, do we allow that somewhere else, or is that a new concept for us in this bill?
That's a new concept.
I'm trying to weigh that policy decision in my head as to whether, if I were to set up a trust and have the beneficiaries named and have a trustee named, I'm trying to think as a body whether we want the beneficiaries then to be able to even have a mechanism to go around the intent of the.
Sure.
And will that lead to more challenges just because of a personality conflict?
Right. What I think we're really trying to do here, because right now it's a very simple code section that talks about showing good cause, and there's a lot of litigation over what good cause means, and really what's following in subsection B here is trying to spell that out. This is what good cause would be.
I'm wondering if we change the confusion for good cause to confusion with what serious breach of trust means.
Or the other point of conflict, when you have the request by all the qualified beneficiaries to remove, then it's up to the court to find that removal best serves the interests of the beneficiaries. Now that should be the touchstone for any kind of decision on the administration of the trust. It should be what's in the best interest of the beneficiaries. Obviously the trustees are supposed to be administering the trust in the best interest of the beneficiaries. So you don't have the ability to just do it by vote of the qualified beneficiaries and then they're out. They still will have to show what may in some cases amount to something like good cause to have them removed. They've got to be able to demonstrate that it's in the best interest of the beneficiaries to do it. And like I said, it can also not violate a material purpose of the trust. And so if a settlor has made clear about naming the trustees that there's a reason why they did, that would govern over just the beneficiaries coming to odds.
I kind of support the reason for you've laid out about a good cause and laying that out in the first 4 sections. I'm just not sure if I agree with the policy change in 5.
Sure. And what I would add to address your point, Representative Kelly, and I understand those concerns, and obviously the policy decisions are above our pay grade. But just in the context of a trust, we're talking about a court determining the best interests of the beneficiaries. If that doesn't necessarily mean what the beneficiaries want, and in fact, many times trusts exist for the specific reason that the people who set them up knew that the beneficiaries, for whatever reason, would not be making the most prudent decisions about what was in their best interest. So it does, I understand your larger point, and obviously the General Assembly may choose to remove that, but the idea is not to empower the beneficiaries themselves, but to put their interest, regardless of whether they actually have a good handle on what their best interests are.
And so if a successor trustee is not named, the court can just take the suggestion of the the beneficiaries, or is that?
The all is important too, because you'll often have disputes among beneficiaries. Any one beneficiary could now do a petition and try to show good cause for removal. This would only be if all of the beneficiaries were joined in on that. So there's some protection there as well. The real protection is that courts are reluctant to remove trustees. That's part of the problem. The good cause standard has been such a problem because it seems to be a high bar in many cases for beneficiaries to have to show. But if you've got all beneficiaries coming together requesting it, then the court, their ability to judge what best serves the interests of the beneficiaries, that, again, it's tied into what is considered the touchstone for every decision that ought to be made about a trust, is what's in the best interest of the beneficiaries. Keeping in mind, it's taken from the Uniform Trust Code, which is now 25 years old, and that language has still been in it.
Thank you. All right, thank you.
I think the code reformers in 2010 had considered that, and I remember looking back at their minutes on that decision, but they went through similar policy questions that you did, and I think our experience in litigation over the last, just seeing it over the last 25 years, suggests to us that that good cause standard is not serving us well. All right, section 80. Section 80 is clarifying on who receives accountings by the trustee. There was ambiguity in that first section about exactly who gets it for what period of time covered by the trustee's accounting, and we're trying to make that clear so that trustees know. 5312.2, section 81 of the code. This is a section that we've thought a lot about. There was a case in 2019 decided by the Court of Appeals, Peterson v. Peterson, that has gotten Georgia a lot of attention around the country because it is the only state that's ever held something like this. You will often create a trust in which and the best example of it is the one from the case, where someone creates a trust for the beneficiary of their spouse and their children, and they make the spouse the trustee of that trust for that spouse's lifetime. And then they may also give to that spouse what's called a special power of appointment. And that's the ability of the spouse to direct where the trust property goes, maybe among the grantor or the testator or the settlor's descendants, but the spouse gets to make that decision, sometimes during life, sometimes at the spouse's death. We have always treated a power of appointment as essentially a personal power that beneficiary has that they can exercise however they would like. And that's usually the reason that a settlor has put it in. This case involved a spouse who made the decision to exercise a power of appointment in favor of some of the children and not in favor of the others. Again, sometimes that's exactly the reason you're giving the spouse a power of appointment. Sometimes it's a power of appointment can be, in a sense, abused by a beneficiary based on their personal desires, but that's why you've given it to them, so they can take future circumstances into
So they have
account.
more discretion in the exercise of the power. They're
Correct.
limited by all the fiduciary obligations.
Correct. This spouse, though, was also the trustee of the trust. And what the Court of Appeals found was that in exercising that power of appointment, that the trustee couldn't take off her hat as trustee and had to exercise that power of appointment consistent with her fiduciary obligation as a trustee. That is a bit of an earthquake as far as what we've always considered the law of trust and the law of powers of appointment. We specifically want our power holders to be able to exercise those powers of appointment. However, even if they are also the trustee of that trust. And so what we've done here is made it explicit that when a person holds power of appointment over property, with respect to which they're also a trustee, that the duties imposed on them as trustee don't apply to that exercise or non-exercise of that power of appointment. And that returns the law to what we really, I think you would have had 99+% agreement among fiduciary lawyers was the law of powers of appointment. And as I said, there's been a lot of criticism of this opinion in some other states, and expressed reference to it in some court decisions in some other states as well about how out of line that decision was thought to be. So this is sort of the one section in our bill here that is actually reversing a Court of Appeals decision. All right, section 82. This is another amendment to the trust powers provision that removes from having to comply with that Uniform Power of Attorney Act rules when exercising this particular power, which in this case it's the employment of agents and that.
That's the incorporation of powers by reference.
Yeah,
Correct.
That's right. This is the incorporation of powers, or now these are powers that apply to all trusts, even if they're not incorporated by reference. That's in that section 23, and section 30 is just an addition to being able to guarantee debt. It's not explicit in our current powers provision, and very often lenders want to see, even though it's pretty clear in our general trust powers provision that you have the power to do really anything that an individual does, oftentimes lenders want to actually see an explicit power to guarantee a debt in the list of powers before they'll accept a trust guaranteeing someone's debt. Section 83.
I believe 83 is just cleanup.
That is cleanup. Section 84 actually removes a section that is just no longer applies. This was about granting powers to trustees, but now that trustees are automatically granted all those powers, there's no need to have any kind of procedure to give them all of those powers that are in section 262. That should have been cleaned up at the time we changed that in 2018. In section 85, let me see. I think this is more, let me say.
Savings provisions limiting powers of trustees, the beneficiary.
Yes, okay. There is a provision, section 270 is the provision of our trust code that restricts certain powers that a trustee has when having those powers could cause them to be treated as the owner of the property for estate and gift tax purposes, which is usually at odds with what you want to happen. It's essentially a savings clause for someone that may not have drafted a trust right that restricts the trustee's powers appropriately. What we've done here is expanded it to include certain other situations in which a trustee can have those kinds of powers and run afoul of the gift and estate tax law, again, to try to prevent that from happening in more trust instruments. That's been a popular provision. That's been in there for now about 20 plus years. Section 86. This just clarifies.
Hold just
Oh,
a second.
sorry,
We've got Representative
Yeah,
Paul.
before you go on, there is a new section though that's being proposed, and I'm not sure that I understand it. So can you explain to us what 2278 to 2281 means in kind of plain language?
Yeah.
I'm sorry,
2278 to
Lines
2281.
Top of page nine.
Yeah, sorry.
Yes. So if you look at the previous page where you see this is a list of certain powers that a trustee has that could cause them to be treated as the owner of property. So the first one there, number one, is making discretionary distributions for the benefit of that trustee. If you can make discretionary distributions to yourself, you could be treated as owning that property because you could just, in your discretion, distribute it to yourself. The new Section 2 is the ability to allocate certain receipts and expenses between principal and income. The reason this is now included is if you, for example, have the right to receive the income of a trust, that won't cause you to be treated as the owner of it because that's an explicit right in the trust instrument. You don't have control of that. But if you have the unfettered ability to declare certain items of principal to be income, then you've essentially have the power to declare any amount of principal to be income and thus automatically be distributed to you. So that's tantamount to having the the power to distribute that property to yourself. So what we've done is we've made sure that having that power to allocate between principal and income won't cause you to be. It restricts that ability to do it to yourself, so that you don't run afoul of that estate tax.
The argument, if you did it, one could argue, well, you didn't really have the authority statutorily to do it. So
Correct.
You haven't committed an act of cause.
That is correct. So the statute itself, it's a savings. This is a savings statute.
Okay.
And then the third one there is where you have the ability to make a discretionary distribution to a third party, but by doing that, you are satisfying a legal obligation that you have to make that payment on behalf of that third party. Again, that would be tantamount to being able to make distributions to yourself. And there that's already been in the code, and there we're just cleaning up the language to make it more clear.
All right, thanks.
All right. I warned you that some of these were kind of technical and related to the estate and gift tax law.
We tried.
All right. Section 86. This is a provision relating to who can enforce a trust, and this goes back to that concept I said about trusts that can have both charitable and non-charitable purposes, and we're making it clear that the settlor of a trust that provides for both of those purposes can maintain that action to enforce the charitable purposes of the trust.
Or someone who's donated property.
Or someone who's donated property, exactly.
Both would have standing.
Yeah. And that's consistent with the Uniform Prudent Management institutional funds that relate to charities in general. Donors to the gift funds and endowment funds at charities have the power to enforce those as well. All right, Section 87, I actually will wait and discuss that when I discuss a change that's made to the end, which we're almost getting to, because the change we made to this Section 87 stems from having made that change at the end. Sections 88, 89, and 90 of the code are just clarifying provisions relating to foreign, what are called foreign entities serving as fiduciaries. Again, this is to harmonize it with the banking code in cases that already do it. And some of these are just amendments to add trust director, where we've previously referred to just trustee. Trust director was a new concept that was created in 2018 or 2020, and we just want to make sure that we tried when we originally went through to mention trust director wherever we mentioned trustee where it was appropriate, but we didn't catch them all. Section 90.
Hold on just a second.
Okay.
And Mr. Jurek, in the insurance code, Chairman Deloach educated us today that foreign means Alabama. not overseas. Is that in the probate code another state rather than another country?
That's correct.
Okay, thanks.
That is correct.
Thank you for that
Foreign is the
levity.
term used there for a non-Georgia. All right. Section 91. This is a change that we have in recent years greatly expanded the power of the Article 6 probate courts. Those are the probate courts in the larger counties that are required to have attorneys as judges. We've greatly increased their powers to handle trust matters. This was a trust matter that, because of the word superior, got stuck, only being able to be done in Superior Court, even though an Article 6 probate court would be a very appropriate court to do that, and that's converting a trust to a unitrust. That's a trust where it provides that all income be paid out. There's a provision for being able to go to court and have the word income sort of redefined as a percentage of trust assets every year, and this allows that to be done in the Article 6 probate courts as well, just by removing superior. That superior was in there back when only superior courts really had powers over trust. Section 92, I mentioned trust directors that have certain, that is a position that we created that allows someone who's not a trustee to essentially have powers of a trustee by being able to direct the trustee to do or not do certain things. This just is clarifying that when a beneficiary appoints a representative to represent them, or there is a representative appointed for that beneficiary, that person hasn't become a trust director for all the purposes of the code that relate to trust directors. That's not what was intended, but there's language in the trust director section that could make you think that being able to represent a beneficiary like that and having certain ability to say things to a trustee or direct things to a trustee makes that person a trust director, and we just wanted to clarify that that's not the case. All right, we're getting close to the end. Section 93, this is just, we've come back and forth with legislative counsel about this language. It was a correction that was done in 2020. We had shall in there, such power shall. This is about certain power in a trust instrument where essentially the estate and gift tax code require that power to be held in a non-fiduciary capacity, and legislative counsel changed shall to is because they have a policy about the way the word shall is written. But what we really were intending by shall was the fact that it must be, when that power must be held in a fiduciary capacity. And so that language now is agreeable to legislative counsel for how to get that across. So that change was really made in 2020. We're just making the language match it. All right. Section 94, I've mentioned trust directors, again, who have certain powers that are like powers of trustees. There is a question then about who can be a trust director, and we wanted to make it clear that it can only be someone that could qualify as a trustee. And so here we are, again, referring to the banking code about who can be a trustee. But we have also added a provision to the end here, and this is something new, and actually we have not seen this in other states as well. Sometimes, traditionally, including in Georgia, people would create certain committees of persons to serve as what we're now calling trust directors, where that committee had the power to direct the trustee to do or not do certain things. A famous example of this that came up in litigation was the rights to Gone with the Wind were held in trusts that had a bank as trustee, but the brother of Margaret Mitchell had appointed a committee of lawyers, accountants, and that to direct the bank trustee on all aspects relating to Gone with the Wind. That committee would now be considered a trust director under the Georgia Code, and that's great, that's fine. But what certain people want to do now is they want to use maybe a LLC or a partnership of people to be a trust director. But right now, an LLC or a partnership couldn't be a trust director because that kind of entity can't qualify to be a trustee in Georgia. You got to be a bank or trust company if you're an entity or an individual. So a committee of individuals could, but not a committee of individuals that are organized as an LLC or a partnership. But what we've allowed here is for a partnership or LLC to serve as a trust director, and the way we've made it work is by saying, but that's only the case if all of the members of that LLC and partnership have individual, joint, and several liability for all the obligations of that LLC partnership. So we've essentially turned it into a committee of individuals. And this will allow some of those trust director committees to now be organized as partnerships or LLCs, where before they wouldn't have been able to. This is a bit of an experiment, actually. We'll see if this works.
But the important point about it, obviously, is now, if we were to use just a garden variety LLC, I mean, as the name implies, limited liability company, you know, in theory, it's a group of individuals and they don't have any assets, and if they violate their fiduciary duties, you have a claim against an LLC and you can't recover. That wouldn't obviously be consistent with the requirements of fiduciary duty. So people can set these up and serve as trust directors, but they have to accept the individual, joint, and several liability that goes with it, so that if they violate their duties, they can be sued, and there will be recourse for their actions.
All right, Section 95.
Hold.
Yep.
Representative Kelly.
What is the, help me understand, what would be the purpose of having them want to organize as an LLC outside of just trying to shield themselves from liability?
So, as I said, very often this was done like as a committee, but there are certain trustees or settlors that want their committee that directs their trustee to be more organized.
Can they just have bylaws?
The committee could, but what's the benefit of an LLC or a partnership statute is that there's a body of law on governance that allows you to take advantage of that, to have that kind of more sophisticated governance. What we've eliminated, though, is what you point out is the usual benefit of having, I guess not always with a partnership, but certainly with an LLC, is that limitation on liability. We're going for the benefits of the governance without the protection of limited liability.
Other states have done it like this?
No. Other states, either it's not clear who can be a trust director in those states, or if you tried to do it with an LLC, and this is what is the case now in Georgia, you'd probably be running afoul of the banking laws that says an LLC can't serve as a trustee, and if a trust director is deemed to have all the powers of a trustee, then you've essentially created like a trust company, but you're not allowed to create a trust company like that. You've got to be a bank or trust company under the banking laws in order to exercise fiduciary powers. So this allows us to have an entity in existence, but it's still essentially the individuals involved who are exercising the fiduciary powers. I've had clients, for example, that don't like the committee idea. They want to have it more organized like an LLC, just because they're either more familiar with that, or they want to do it in the that want to organize themselves with an LLC operating agreement, because that's something they're very familiar with from the other business. It may be a same group of people, for example, that act as investors, and they might do their investing in LLCs and that as well. And so they want to use maybe an existing LLC that serves as a general partner or a 1% owner of a syndicate of investment LLCs. They want to use that as the investment director or trust director for a trust. And right now they couldn't use that entity. But now if they insert it into their LLC operating agreement that said, with regard to all of our exercising of powers as a trust director, we have joint and several liability for that, then they could just use that existing entity as a trust director without having to organize anything new.
I understand. It gives me pause that no other state has done something like this, and and it's being put with so many other good things that I think probably need to be done as kind of a omnibus bill here, and I almost wonder if it's something that may need to be debated on its own merits.
That's fair.
Okay.
All right, final section 95. This adds a new article, and this is the one Kyle mentioned earlier. This essentially makes the Uniform Electronic Transactions Act, which is the act that was passed way back at the dawn of the internet era in 2000, that essentially is what makes all the electronic contracts you've entered into over the last 25 years legal. The clicking to accept terms and conditions, and also DocuSign. If you've ever done signed an agreement that way, where you just click sometimes on your phone in the blanks to sign your name, all of that is authorized by that Uniform Electronic Transactions Act. That law was written in a very, very commercial setting. It was written to make commerce work electronically, what had formerly required pen and ink signatures on contracts. And it's always been unclear whether that act, to just take the basic example, whether you can DocuSign certain kinds of estate planning type documents. A will, that clearly you can't. The Uniform Electronic Transaction says you can't do a will that way. There's a very narrow carve out. But it's never been clear, for example, whether, say, a contract between a trustee and beneficiaries for releasing at the end of the trust to release the trustee from liability so that we can terminate the trust. Could you do that by DocuSign? Trustees have always been a little nervous because that's not really not purely a commercial transaction. And so there's been hesitancy to do by DocuSign a lot of the things that are done in relation to trusts, wills, and things like that. So what this does is, using pretty much the same language that has come out of that Uniform Electronic Transactions Act, as well as some language that is in a new uniform act called the Uniform Estate Planning Documents Act, Electronic Estate Planning Documents Act. That is an act that the Uniform Law Commission did that basically lets you do by electronic everything. Every document they could think of relating to estate planning, they have thrown into that act. That was a little much for us. We'd rather some other states experiment with that before we jump into that, because it included powers of attorney, designation of conservators and guardians for minors, wills, trusts, everything. So what we've done is narrowly focused on just the administration of trust. And what it allows is, anytime there is notice that has to be sent to beneficiaries, or consent by beneficiaries to certain actions, or reports that are sent to beneficiaries, or the non-judicial settlement agreements among the beneficiaries and trustee of a trust, or any other matter in the trust code relating to trust, or anything in the trust instrument that relates to the trust that you're implementing, to be able to be done electronically if it could be done before by a written agreement, and for any electronic signature on those to be treated as a signature. Again, that's language that's been around now for 25 years in the commercial setting. And this is what would implement that. The one exception being the writing that creates a trust. That we've still require to be in writing, and we've not changed the traditional meaning of that.
So you still have to have a paper trust agreement?
You do. Correct. And if it's a trust created under a will, of course, you would still have a will that's done by writing, because we've not touched the rules about execution of wills. Some states have now gone to electronic wills. That is something we have heard a lot of opposition for among practitioners in our state, and so we have not gone there. I mentioned an earlier section that I skipped. This is the section, it was number 87. Statute of limitations for breach of trust. Normally, those are triggered when a document that discloses the existence of that breach is sent to a trust is received by a trust beneficiary. And that starts a 2-year statute clicking. So if a trustee mails you a statement and you get a statement, and on that statement is disclosed what you could have complained about in terms of breach of trust, 2 years go by, the trustee has a statute of limitation run. That's been the law for a long time. What we've changed is instead of date received, we've tied it to date sent, so that it then harmonizes with all of the send concepts that we've now incorporated in this provision that makes it very clear what it means to send, both by traditional means and electronic means, any kind of record or notice to a beneficiary. That could include, and this is of interest to a lot of trustees, making a statement, for example, available on an electronic portal, which is the way that a lot of statements are now sent to investors. And that any of you that have investment accounts, you may have opted out of getting paper statements in the mail and are just get a notice of when a statement is now available for you on an electronic portal. This would allow that as well, but there are protections for being made aware of that, being made aware of the electronic portal, opting out of the electronic portal, etc. So we're hoping this will allow it to be done by electronic. What we started doing a lot of during the pandemic, which was doing DocuSign to do a lot of this, but always being a little unsure whether it was really legally recognized.
Okay, we have a question from Representative Holcomb.
Yep. Thank you, Mr. Chairman. I want to direct your attention to lines beginning 2638, which is on page 104. I understand the first few lines, and it's talking about notarizations, but I'm not sure that I understand the tail end of 2640 through the end of that, 2642. Can you explain that? And what it's asking for is to include additional information when a document is notarized, and uses the term logically associated. I've never seen that before, and I'd appreciate some explanation.
This is if another law or a trust instrument requires a signature to be acknowledged or notarized, then that's satisfied if basically the evidence of that notarization, meaning the signature and the notarial seal, and that is, and by that logically associated with, it means is part of the same, essentially, electronic file. So it could be very well be as part of the same electronic file that contains the documents. That attached to or logically associated language is part of the Uniform Electronic Transactions Act and a lot of uniform codes that have now been amended to include electronic concepts as a way of encompassing the concept of an electronic file that has essentially a electronic attachment to it. To use one example, it's just the pages of a PDF are all logically associated with one another when they're a part of the same PDF file, for example. But you could also conceivably have, for example, DocuSign. If you've ever done a DocuSign, you know that there are a finalized DocuSign document comes with evidence of the chain of signatures and that can sometimes not be actually part of the document, but is logically associated with the document by a very long DocuSign code, and that you could, through DocuSign's records, you can associate then that electronic chain with the document that was electronically signatured. That would be an example of a logical association where they're not actually physically attached to the same file.
Okay. All right. Thank you.
This does not, however, authorize electronic notarization, which is a whole separate issue that you'll deal with the real estate lawyers on. We're not getting anywhere close to that issue.
Judge Chairman has a question there.
I had to go vote in another committee and miss part of it. Can we start back over in section 5?
Hell no.
Thank you, everyone, for your patience. On
Very
this.
much appreciated.
Gentlemen, I want to thank you for the very thorough explanation of this bill. I never want to go through that again.
We tried to spare you.
If I would note for the record, we did everything we could to spare you.
And I promise you, Rob, that I'll get in the well and I'll say, trust Rob.
Yeah.
So, all right.
Well, I hope it would be trusted to me. We're not exactly known for being slackers when it comes to vetting.
That's true. That's true. Anybody else have questions? I know we have a potential amendment to be discussed, but let's get the.
I'll make a motion.
Oh, we have a motion. All right. Second. Okay. Representative Kelly, you got a.
I'm going to have two amendments, Mr. Chairman. I got one that's going to be this new section I want to add, and then I've got maybe. No, I got one to the language of the current bill as it exists. Maybe a second one. Which order do you want me to go in?
Whatever you think makes sense.
All right. Yeah. Why don't I just still have pause when it comes to Georgia trying to do something we don't know has been done anywhere else and with the LLC organization. So my first amendment that I would offer in the form of a motion would be to strike lines 2436 through 2438 on page 96.
2436 through 2438.
And 2455 through 2462.
2455 through what?
Just the remainder of the section.
2462.
60. Oh, I got you. Okay, the rest of it.
And just to clarify, I mean, and I understand obviously the concern with subsection G. The subsection B, 2436 through 2438, is talking about corporations, partnerships, or other entities that have the power to act as trustees. I understand the concern with other entity, if that's the issue with it, but we would ask that some version of 2436 to 2438 remain in the bill.
So what
I
would
understand that you're making a material change to existing law.
if I want to get rid of 2455 through 2462, what needs to change on 2436?
I think, Kyle, with lines 24, if you look on lines 2434 and 2435, where it says if a trust director is a corporation, partnership, or other, it shall be required to have the power to act as a trustee in Georgia.
Right.
That's where we wanted to make it clear that we were not trying to create entities that might be bank or trust companies. So I think actually you if you want to eliminate G, I think you can also eliminate B.
Okay, then all right, then I'll.
All right, I'll offer that as a motion if somebody second it. All right.
I got a motion and a second. Any further discussion on the amendment? Well, I'll get to when we. I'm sorry. Go ahead, Representative Hatt.
Representative Kelly, are you still intending to change 2441 to 2443? I think that's the only other part that has a change.
I think 2441 and 2442 were needed just as a cleanup mechanism, not a policy shift.
Okay,
as I would consider it.
Sorry, that may be my bad. So we're just striking 2436 to 2438 and 2455 to 2462?
Yes.
Okay. Sorry about that. That's my bad.
All right. I'm giving folks time to absorb it. All right. I don't think I got a motion for the bill, did I?
Oh, yeah.
I do? Okay, now we're on the amendments. All right. Lost my place there. All right, what's the will of the committee for this amendment? I have a motion and a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, we have that amendment. What's your other amendment?
I want to maybe just have a discussion about, and I've lost the line now, about where you said we'd be making a policy shift in terms of sent versus received.
Oh,
where is that? Because that
so
is
yeah. So
Yeah, 87, I think.
It's in 87, but first go to let's see, 53-12-511, which is on page 98 of the bill. It was far easier to, when implementing this electronic sending of notices or records, to regulate and impose a lot of rules and a lot of safeguards in terms of the sending than it was on the receiving. And frankly, receiving is kind of an odd. It's proof of that is really is a lot tough. It's a lot harder on the trustee, I guess, in a sense.
And that's what I'm trying to say. Who policy-wise, who would bring that? You know, if somebody were to bring a breach of, you know, fiduciary claim against the trustee, and who should have the higher? You know, I guess I'm trying to figure out who should have the higher burden here. Should it be easier for the trustee to kind of say, well, sorry, man, you got your notice, 2 years ago, and he said, well, I didn't actually read it until, a year ago or whatever. I didn't realize I'd received it.
Get it.
Yeah.
Right. And so if you look at starting on line 2501, this is the first time we'll have in the code. And again, I said it's electronic and traditional. So if you look at where 2501 starts, it talks about notice to a person or the sending of a record to a person and how that is to be accomplished. And it's to be accomplished in a manner that is likely to result in receipt. So in a sense, it's still focused on making sure it gets received, but it, for the first time, lays out certain rules. So you look at the top of page 99, that's presumed likely to result in receipt unless proven otherwise by clear or convincing evidence. So you can prove, I never,
Does that mean what if it went to a spam folder? I give the Speaker's office my personal Yahoo email account here, but sometimes when meeting notices are sent out because they're coming from a house.ga.gov website to a large list of people, it goes to my spam and I never see it.
So that would be an example of where you could prove that it did not get, in a sense,
how
it was not accomplished.
Right.
That notice or how?
Yeah.
Well,
because I can always move something to spam or out of spam.
Right.
And I don't think you ever hit your clear and convincing.
Then you're down to just the traditional kind of factual disputes and evidentiary disputes, I think, that you would get even under the receipt, a standard that was on received rather than sent. And what we're trying to do here is just provide some clear mechanisms for being able to send, for how things should be sent, so that they are most likely to result in receipt. So everything from personal delivery, literally handing something to someone, to the classic, registered or certified mail, which is not always a surefire way of getting things anyway, but that is all over our law in many other areas besides trusts and estates. And then we have the new electronic ones as well, which include email and electronic portals.
And we didn't, and I understand your concerns, and we tried to address those. Frankly, we didn't, because we've been here a while, and I know this is not the most exciting stuff in the world. So we didn't go into quite as much detail, but for instance, under 2568, line 2568 on page 101, in dealing with whether notice or the sending was reasonably suitable under the circumstances, specifically under paragraph 1 for the statute of limitation, the sending in a manner that's likely to result, to be presumed to have accomplished, it was reasonably suitable. Then for all other purposes, that it was reasonable, determined in the context of the subject matter of the notice or record, the length of time, imposed with respect to notice, the circumstances of the person, sender's knowledge, when actual receipt, if any, occurred. So there is an effort to impose a facts and circumstances test that would include how important is this. I mean, are you just sending me, a standard garden variety update that it's not a big deal if I ignore, or is this something that is designed to trigger a statute running?
But if you could prove this crucial piece of evidence went to a spam folder.
I don't know if I ever could do that in a clear and convincing manner, though. And again, I'm kind of thinking when you're talking about trust and trustees and beneficiaries, largely you're talking about some substantial amount of assets that could be at play here, and I'm wondering who should have the protection, the trustee or the beneficiary. And I think we're making a big policy shift when we're talking about that, and I don't like it, but I don't know all the places I need to make changes to correct it.
We had thought that if changing this was worrisome to the fiduciary litigators, that they would have let us know, and some of them had a hand in helping review and draft this, and we did not get any concerns by them that that this was significantly changing the burden, that it was more providing meat on how actual notice is sent and received that had never really been in the law before. I totally see what you're
Sure.
what you're
I
saying.
guess maybe, and I can ask the author this, maybe in lieu of me trying to figure out an amendment here today, if we get this to rules and we start hearing some concern about that, is there a commitment to move it back here so we can fix it?
I mean, I know.
That's for.
Yeah, I guess that's for you, Rob. Sorry.
Yeah, no, he's asking me that.
Yeah, I know. My apology.
I suppose if that's what I need to move the bill, yes, but I think you are taking certain sentences of the act and ignoring what is about 3 pages of provisions that sort of claw back some of that presumption and attributing more significance to one part than you are to the others, which to me kind of balance it back.
And that's kind of what I want to take the opportunity to be able to read through this and as we're trying to make this, because I mean, it's acknowledged it's a big shift in how we're doing things today. It's a fundamental shift as to.
I don't think it is. That's the point I'm trying to make. I think when you take it all together, it's not a fundamental shift. It's taking a lot of existing rules and just codifying them. But I acknowledge I may be wrong in that, and I would like you to be satisfied. So
Okay. As long as we have that understanding, then I won't try to do anything with the amendment
I
here.
would just ask that you let me know soon, because, train's going down the track.
I know, we got 8 days. All right, then I'll move on from that, Mr. Chairman, but I do have the other thing that y'all printed off.
Okay.
That I want to add.
All right. Representative Hong.
Thank you, Chairman. And I have the same concerns that Representative Kelly did. And I think, I won't take more time, but, when it comes to notice, we always make sure somebody has received, its answers are due when we have something that shows that they've actually received, et cetera. So changing that from sent, that does concern me. And I know, Chairman Leverett, you mentioned we're not really changing, and I don't know as far as what the practice has been, whether sent is okay in this area of law. I think that's something that we need to know a little bit more about before actually changing that. I'm just more concerned with what if people don't receive it, what if there are loopholes, what if versus and just saying I sent it, that's it, that's all I did in the end. So so I share the same concerns that Representative Kelly does.
If I could respond, I don't think that's really what the bill in total says. I don't think it says the trustee can go, well, I said it. Sorry. Statute's run. I think there's a lot more that's got to be established to do that. But I want everybody to be happy with the bill. Right. So we're going to work on it. I just hope you'll help me work on it quickly.
Thank you.
Okay. Any other amendment? You want to go ahead and take care of this one now? The one that you have proposed?
Yes.
Okay, all right.
So I think we've passed out some language.
I don't believe we've seen it on this side of the table.
Yeah.
Okay.
And it's not doing anything substantial to the language of this. It's something that I consider germane to just what we're being discussed, which is, charitable donations and donations. Last year, we passed a piece of legislation that dealt with protecting individuals' information when they were making donations. In that bill, we gave some exceptions for when they would need to comply with state reporting and different agencies we wanted the information to be disclosed to. And we inadvertently left out the Department of Early Childhood and Learning. And they need to be able to get that information because it could relate to a child nutrition program. And I felt like while it's germane, instead of running one of my 10 bills, that maybe I could take a ride with you on this, Mr. Chairman, and I would just add the language in section 1 that's in front of you here, and I would just make that a new section 96, and then make the existing section 96, 97. I would offer that as an amendment.
All right, are we sure this is germane? I don't think we touched Title 50, do we?
Well, we've jumped around in several. We're in multiple sections already. I mean, we're in 53.
But they all have to do with trust law.
Or donations. I think germaneness is just a question for the chair, and we've touched 7, 10, 15, 19, 53 as it's all related. I would say it's germane in that it relates to the donations. It doesn't necessarily become germane just because it's in the same section as the bill.
I'll buy Representative Kelly's argument on that.
Thank you, Mr. Chair.
It's to nonprofit organizations.
I'll move. Do we have?
Okay, do we have a second? All right, motion and a second. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right. That's that. Now we have your 2436 through 2438.
We already did that.
Did we?
Yeah.
I don't recall that. Okay, all right. And so,
Been a long afternoon, Mr. Chairman.
it has been. Did that also include the 2455 to 2462? I remember us discussing it. I don't remember us actually voting on it.
It was unanimous.
All right.
Yeah.
I'm glad to hear that. Okay, so any more amendments?
I'm good, Mr. Chairman.
All right, so now we're down to the bill. Any further discussion about the bill with the amendments? Hearing none, all those in favor say aye.
Aye.
Any opposed? Okay, your bill goes up for a while anyway,
Thank you.
unless clawed back. Yeah.
I just want to know, I've never had a representative ask me to hold a bill, but then also use it as a vehicle.
That may mean I don't want it held.
You will think twice
Kelly's been
about
here a
holding
while.
Yeah, you may need to learn something about negotiating.
Practice probate law now.
All right, anybody on the committee need a break? Or are you ready to keep going?
Let's go. Let's get through.
Well, I do, Mr. Chairman, joking. I'll be right back.
Well, as long as I still have a quorum, I'll keep going. All right. You next. 132? No. Yeah.
Let's go, Matt.
All right, Representative Reeves, tell us about House Bill 132.
Thank you, Chairman Gunner and members of the committee. House Bill
132 is the municipal judicial bill, and after nonpartisan courts and fiduciary law, this one deals with something we might be more in court with municipal court and sovereign immunity.
Is your LC on this 473311S?
It is. This is a substitute that I circulated a couple of weeks ago and invited review and comments, and I appreciate the committee members and GMA and those representing victims in claims against cities working on this. This sub, let me cover the senior judges portion first. That's sections 1 through 3 of the bill. Judge David Will was here earlier. He had a calendar call to go start. He's a municipal court judge in Alpharetta, Sandy Springs, and Clarkston. And Judge Charles Barrett from Duluth wanted to be here, but he was trying a case this afternoon. But the municipal court judges, they're on the front lines of municipal citations in my county. In the unincorporated area, it's Recorder's Court for traffic issues, but with Gwinnett having 15 or 16 cities and with Georgia having 537 cities, municipal courts often handle traffic and other criminal offenses. These municipal court judges are frequently part-time judges who are well-respected lawyers in the community who've gotten nominated and appointed by the mayor and council, and they are well-respected members of the legal community, and they see a lot of cases for Superior Court, for State Court, many other courts. We are able to call upon senior judges to have on the rolls, to keep their certification up and to fill in when needed, to keep the caseload going through, and Lord knows the caseload is high in municipal court. So the municipal court judges have asked for a designation under Georgia law to recognize senior municipal court judges to be able to bear upon their experience. The tenure would be an aggregate of 10 years service as municipal court judge. And again, these are often part-time judges, so after 10 years, with the judges often having experience already as a practitioner, to be a judge for 10 years, that would give them experience so they could step back from being a full-blown part-time or full-time municipal court judge to one who is called on a one-off basis to cover calendars and things like that in their area. So that was the request. The Judicial Council has been fully involved in reviewing the request and supports the measure. GMA has also reviewed it, has no opposition to the bill. The bill does not have a fiscal impact of the state and doesn't, impose anything on the locals. The locals still get to choose whether to implement this pursuant to their local rules regarding municipal court judges. So this is just something to recognize the position under Georgia law, and is a bright idea from years of experience from municipal court judges. It does have provisions about keeping their license current. If they move to another state and they don't have the bar license, there are provisions where they could come back just for the senior judge work if they retired at Hilton Head or something like that. But it has a very specific provision in section 2 and 3 of the bill, which puts guardrails on this new office. So that is the senior municipal court judge portion of the bill. And then section 4 and following is the sovereign immunity matter. And as we were looking at the municipal judicial issues, there's a concern that the cities have brought up. There wouldn't be municipal courts and municipal court judges without the cities. And it's my understanding in decades past this issue was reviewed by this committee about addressing sort of a gap in Georgia's sovereign immunity for cities under certain circumstances. Of course, if a city vehicle has insurance, there's a waiver of sovereign immunity via that. The state has a waiver of sovereign immunity in Title 50 up to $1 million per claim or $3 million total on an incident. And then counties arguably have full sovereign immunity. So cities have a large amount of liability, whereas the state and counties have a predictable amount of liability, which allows them to insure and budget based on that known risk. And so what this bill does, and this is the request of GMA, in Section 4, they request, Section 5 on page 5 of the bill, they request the amounts that the state has. And this number is from several decades ago, but the state still uses it of $1 million per claim or $3 million per incident, per occurrence. And there are some other provisions there about punitive damages, interest. There are specifics on that. And so it keeps, in effect, the sovereign immunity waiver for car accidents, but it does put the sovereign immunity waiver amounts similar to the way the state does it, so that cities will have a known risk for claims so that they can insure or budget accordingly. Just looking at cities, as I mentioned, there are 537 of them in Georgia. 75,000 of them have a population of 5,000 or less. The revenue of those is, let's see, 311 of the cities have a revenue of 5 million or less. 293 have revenue of 4 million or less. 271, or about half of them, have revenue of $3 million or less, and the median is 2.6 million. So examples of cities with less than 3 million of revenue, there are a lot of them from northeast Georgia: Hull, Carl, Colbert, Danielsville, Comer near Athens. There's Young Harris up in the mountains, Lincolnton over near Augusta, Waleska, and Cherokee County. So these amounts definitely fit in with the budget, the city budget, that the taxpayers are bearing on that. Cities with a larger revenue, of course, they have more incidents. So while a single claim may be tough on a small city, and you may think, well, the bigger cities could absorb it, they have more traffic and various issues that give rise to claims. So, whether you're a small city, a medium-sized city, or a big one, this is something that's concerning. There was a jury verdict in Fulton County against the city of Milton over the past couple of years that was subject of a court case that was $35 million. I think that's what got the city's attention. It definitely had some unique circumstances, and I'm not, presenting that as the reason for this bill. I think the reason we're bringing this bill is the cities, according to the Court of Appeals now, after a lengthy lawsuit, they've got a gap in sovereign immunity that is very different than the state, the counties, and puts a huge liability on our cities. If a city has a disruption in their budget, a lot of cities have police departments and are otherwise first responders. That's going to endanger public safety and delivery of public services, and ultimately be a burden on the taxpayers. So this is a very common sense, real world, albeit complicated, sovereign immunity issue that the cities have requested. In terms of the landscape around us, Alabama, they have, and definitely I'm not suggesting Alabama as the model for any Georgia law, but they have 100,000 per incident or 300,000 per occurrence. Tennessee is 300,000 per person or 700,000 per occurrence. North Carolina, they have that insurance waiver like we do with vehicular insurance policies in Georgia. South Carolina, it's 300,000 per plaintiff or 600,000 per occurrence. Florida, and they're debating their numbers right now in Florida. They're 200,000 per person, 300,000 per incident. There's a proposal to raise that to $1 million and $3 million, and they would graduate beginning in 2030 to 1.1 million and 3.2 million. And then Texas is $250,000 per plaintiff or $500,000 per occurrence. So that is the municipal judicial bill, which it is a huge concern to our cities. I know they are keeping an eye on this. We have several of them here. I know it's important, the Seventh Amendment trial by jury. This is one of those, as we mentioned earlier with the probate bill about policy issues, this definitely is a policy issue. And so I'm proud to be here with all of you smart lawyers and elected officials to take a look at this policy issue and make a move in light of the landscape in Georgia and our southeastern U.S.
Okay, I have a question. How is the municipal senior judges, how are they organized? How do they get notice that they're needed somewhere, and how much do they get paid?
That would be a city-by-city decision. The Judicial Council would supervise the organization just like they do municipal court judges. They would certify the credentials, I believe, on page Section 3, page 2, lines 34 to 42. So Judicial Council will get to oversee statewide and the applications, but the locals would pay them. As I mentioned, Judge Will is a Alpharetta, Sandy Springs, and Clarkson judge. He has a different pay for each city, and so it's something that is discussed by the city officials and the judges, both as a full-time, part-time, or senior judge.
Okay. In the superior courts, they have district court administrators that organize the senior judges. So they get the call that there's a need for a judge in a court to cover it because somebody's sick or whatever. Is that what you're describing to me?
I know that the municipal court judges in my area meet and they stay in touch. I don't know if they have a formal organization like the district court does for superior court. Maybe one of the city officials, or I'm inviting to phone a friend there if anybody knows that. But I do know that in my area, the part-time and full-time judges call on each other. And there's, a custom of getting them called in, and so whether that's formal or informal, I don't know.
Representative Kelly.
Got a couple questions, Mr. Chairman, but the first one may be more to Legislative Council as to whether the reorganization of senior municipal court judges and waiver of sovereign immunity, if that's a multi-subject, if this makes this a multi-subject bill that could then be challenged. I don't want us to do something that could be challenged in court on two very important issues and be found to be unconstitutional because they're multi-subject in nature. And I kind of wonder with that. We're talking about our municipal judges in one area, but then we're talking about a waiver of sovereign immunity. And it'd be interesting for me just to know if it could be a multi-subject.
Well, everything in this brief bill is in Title 36. We just had an amendment on the last bill moving Title 50 into a bill with nothing there. But I mean, these are certainly important municipal issues and legal issues in the same title. So
I don't think the test, like I kind of said last time, I don't think the test is necessarily based on title. I think it can be based on this your Section 2, but that's fine. If we've reached that, I just want to mention that. Yeah. I'll hold for right now, Mr. Chairman.
All right, thank you.
But I do have that concern.
Understood. Who's got number 5 over here? Oh, Representative Evans.
Thank you, Mr. Chairman. It's been a minute since I've dealt with the Tort Claims Act, sovereign immunity. Can you we've been here a while, so I don't know, we're capable of brief, but just a little tutorial about when it comes into play and how it can potentially go away. There are definitely instances where this could be waived, even if we pass this. Am I correct in that? Do you understand what I'm asking? Like just a couple of
Let me
review.
maybe start with the entire landscape and see if that answers the question. So if state, county, city, if they have a vehicle and that vehicle has insurance, the sovereign immunity is waived up to the amount of that insurance. So that covers the most frequent claim of a car accident, similar to businesses or individuals. The state, for miscellaneous tort claims, you can go try the case, but at the end of the case, it's going to go, if the verdict exceeds $1 million for an individual or $3 million for an occurrence, it gets remitted down to the $1 million and $3 million. For counties, they argue that they have sovereign immunity with no waiver. There's a doctrine about ministerial act versus legislative act, and so it gets a little complicated there. And then with cities, it was the Ching case, C-H-E-N-G versus City of Milton up at the appellate level. Court of Appeals did the analysis there that sort of confirmed what people here had discussed over the decades, that cities, have some exposure, big exposure on sovereign immunity. So that's the general landscape.
That helps.
And the waiver, you have a waiver through the auto liability insurance or through the state statute, and this would be a waiver by cities, but it would set that amount as the state amount
limits,
rather than unlimited.
Okay. And I have two specific questions, if that's okay. How many times, or do you have any sense sitting here today of how many verdicts or settlements might be out there with cities that would exceed these caps? Like if this was the law, say 10 years ago, how many potential recoveries would we have been wiping out?
I don't have statistics on that. I think the cities, I believe it was a plane crash at an airport years ago where folks said, this may be something that could affect a city budget or make us, uninsurable, or you could never get insurance for that type of an amount. And at that time, I think it was like $3 million or something like that. That was years ago.
Okay. And maybe somebody can answer that, or we can find it out later. And then my other specific question is the language on right at the very end of line 100 to line 102. The existence of these caps shall not be disclosed or suggested to the jury. Is that language that appears in other areas of the code where we have these limitations?
I don't know that the Title 50 state language has that in there. That may be new language.
Okay. And then my last question, and I mean it, is I get sometimes we combine, certainly in a code rewrite, I understand why we combine a bunch of things in one bill. Certainly I understand when we're dealing with our friends in the Senate and we light up Christmas trees because we're running out of time and that's our only way. But we're still so far from crossover in legislative time. Why not have a standalone bill that stands on its own merits? Why are we adding to a bill that, I don't see has anything to do with these waivers?
Well, certainly to the cities and to the judges who are part-time lawyers frequently, they are very much related. They were, in the same area of Georgia law regarding the same parties. So this is something, that was drafted and circulated weeks ago. That is, valid question, but, it's not one that's been brought up. It fit in well with that senior judge's Title 36 legislation because they are knowledgeable about this issue as well. From what I understand, it's the number one issue of the Georgia Municipal Association this year. It's their concern. So we had the senior judge's bill filed. They brought this issue up, and we got it presented to you in this fashion.
Thank you.
Okay. And also, having multiple bills over in the Senate always can be dicey. If you have all the municipal issues in one place, it's easy to focus on it rather than, things getting lost in the shuffle.
Representative Kelly.
Do these municipal judges hear civil cases?
No.
Okay.
It's generally citations. So, code citations, I guess, would be quasi-criminal, but
I know how strong our municipal association is here, and this being their number one issue. Do you know, every conversation I seem to have up here revolves around a couple Senate bills that are meant to deal with excessive litigation, and I guess the question is, do you know if the municipal association took this language to the governor to ask him to include it in what he considers necessary tort reform?
I'll let them answer that.
Okay.
All right. Who's got 7?
Me.
Judge Scoggins, go
Yes.
ahead.
Thank you, Mr. Chair. This is just a random question. Is there a way to set these caps up based on the population of the city? I mean, is that going to get too far out into the bushes?
This issue that's been raised about the subject matter, I know population is something that definitely gets.
I mean, we deal with a lot of things with population
Right.
and makes things fall into effect.
But I think the Legislative Council definitely discourages, population and
Okay.
the surrounding the surrounding states, and sovereign immunity. It applies to small cities, medium size, and big cities.
Agreed.
So the amounts, I have not seen a precedent for that.
Okay, thank you.
Chairman Smith, is that you on 14? Yes. Okay.
Thank you, Chairman Gunner. Appreciate that. This is their number one issue, isn't it true? To my friend, Representative Reeves, I wish that number one issue or co-issue would be fixing all the potholes that I have to hit when I'm coming in from Haralson County, taking time away from the line of defense against Alabama. I would ask this question. I tend to agree with my neighbor from just north of me up in Cedartown in the 16th. Correct me if I'm wrong, just because it's in the same title doesn't mean that it doesn't touch on a different subject matter. That's been my understanding here, and I know sometimes certain, folks on the other side push that issue. But we pride ourselves in the house of not wanting to get something overturned across the street. I know that's a concern that I've talked about when we had you on our committee. Still, we miss you. But, that's just kind of a concern we've had before.
Sure, and I think that rule revolves around notice, and clearly at this early stage, with it all being municipal issues, I think everybody's got notice of what this bill's doing. So I think having it from the first hearing rather than something done at midnight, I think definitely honors the spirit of that principle, and with all the code sections lining up and with the affected parties being the same people regarding municipal legal issues, I think it fits in well with that landscape.
Representative Silcox.
Thank you, Mr. Chairman. Just to add to Representative Evans' question, can y'all hear me? This is not working.
Yeah, it doesn't have the phone.
Can you hear me now?
Yeah.
Okay. Just to follow up with Representative Evans' question, I think that that this has also been brought forward because of the failure of the legislature to decide on premises liability. So I think all of the cities in Georgia are nervous about this. All the counties are nervous about this. All the businesses are nervous about this because there's basically not a clear limit on liability for anybody.
I would respond and say this is an issue of sovereign immunity that predated the issues that are under discussion in the Senate right now. And this is an issue that jeopardizes city budgets, public services, taxpayer funds, and we can honor Seventh Amendment trial by jury and civil justice and compensation to victims and have something that could be insured and budgeted. So I think you could do both.
Okay. All right, I don't see any other questions. I have, let's see, 3 people, 4 people, 4 people, 3? Oh, okay, got it. Sorry. Do y'all want to come up together, or how do you want to do that? We'll come up together. Okay, all right.
Thank you, Mr. Chairman. Rushi Patel with the Georgia Municipal Association. With me, I have Mayor Bianca Motley Broom from the city of College Park and Mayor Kurt Ward from the city of Brazelton. much like Chairman Leverett, I'm using my phone a friend. I hope it doesn't lead to 4 hours of debate, but if it does, we'll be here. I want to talk a little bit about the scope of this legislation, particularly sections 4 and 5. We are good with sections 1 through 3 with the senior municipal court judges at GMA. But sections 4 and 5 are our provisions, and Chairman Leverett, Chairman Representative Reeves have been very helpful with these discussions. I want to thank them too. Going into section 4 and 5, talking about the scope, and I understand that there may be a proposed substitute, and I want to talk about the scope in relation to that proposed substitute and the language there too, because I think it matters. But starting with section 4, we have language in section 4 of 3311S that talks about joint projects. And joint projects are very important for cities and counties in the state of Georgia, because cities and counties working together to create bigger projects are very important for local communities. Cities and counties can often not create those projects by themselves, and working together, they can do things better and bigger. So those joint projects are very important. However, we have a dichotomy breakdown there when it comes to cities and counties. Counties have a higher, stricter sovereign immunity than cities do in the state of Georgia. And honestly, this is through some 30, 40, 50 years of judicial precedent and interpretations of the Constitution. The Constitution is pretty clear that the state and local governments have sovereign immunity, but that sovereign immunity can be waived by acts of the legislature. And so we've ended up in a different place than the counties in the state. And so what ends up happening with these joint projects is that we end up in a situation where if something goes wrong on those joint projects, because the county sovereign immunity is higher than the city's sovereign immunity, the city can be left covering the entire situation instead of having a split. And so in this situation, we're asking for the cities to be raised to the same level as the counties on only those joint projects in section 4, so the sovereign immunity is equalized. You'll also notice a change in our proposal in section 4 of lines 90 through 91 that talks about the immunity of consolidated governments. Now, there's a few consolidated governments in the state of Georgia: Athens, Clark, Augusta, Richmond, Macon-Bibb, Columbus, Muskogee. And when you look at those charters for those consolidated governments, they either say one of two things. They say that the immunity of that consolidated government is that of the counties, or the immunity of the consolidated government can take from both cities and counties. So in most situations, in fact, I would imagine in all situations, those consolidated governments are going to take the county, right? This is just placing in state law that the consolidated governments would have the immunity of counties. So that is section 4. But I really want to focus on section 5. So section 5 is the area that is our largest priority. Representative Reeves is correct. We have taken this language, for the most part, from the State Tort Claims Act. And I can provide you those citations. So section A comes from Code Section 50-21-9. And Representative Evans, to your question about the last sentence, in that it's a direct line from 5021A. So, and I think it's paragraph B of 5021A, the last sentence there. So what the state has done for itself is, and Representative Reeves is correct, they did this about 30 years ago, I think, with the State Tort Claims Act, and provided limitations of $1 million per person, $3 million per occurrence. That $1 million, $3 million has applied to the state for that period of time. And as Representative Reeves noted, our neighboring states are all lower than us, and significantly lower than us on those numbers. We are not asking to be lower than the state. We think what is good for the state should be good for cities. And so you'll see a reference in here to the Georgia Tort Claims Act, which is the State Tort Claims Act, and the same numbers as the State Tort Claims Act. We think what is good for cities, or what is good for the state, should be good for cities. 1 million, 3 million. What is interesting here is that that 1 million, 3 million, again, is very much higher than our neighboring states. And when Representative Reeves talked about our membership, 537 cities, most of our cities are very small cities. So $3 million is more than they bring in every year. And so these other states have recognized this as well, and that is an issue there. The next part, paragraph B, the no award of damages. The first line there on 103 is a direct line from 50-21-30. Paragraph C, the first part there with the 7% interest, is directly from 50-21-31. And paragraph D is directly from 50-21-29. Now, I want to talk about the differences between the scope here in 3311S and what I see as a proposed substitute, or maybe a proposed substitute of 1507S, because I think it really matters. In this proposed substitute, if I think it goes to, I want to talk about a few things. They have a new proposed section 5, which would increase the ante litem period for cities from 6 months to 12 months, which would give plaintiffs a longer period of time to file their notice that they are going to sue you to the cities. But particularly looking at section 6, there are some significant changes. One thing you look at section 5 of 3311S, the application of the 1 million, 3 million limitation is to the entire chapter. And that's important because the chapter that we're placing this language in is the liability of municipal corporations for acts and omissions. That chapter includes waivers of sovereign immunity and the current waivers of sovereign immunity for cities. But what's proposed in section 6 of 1507S is different. The language in 1507S, section 6, would limit the liability, the 3 million, 5 million proposed there to only that code section. It wouldn't apply to the rest of the chapter. So the existing waivers that we are seeking protections from, it wouldn't do anything for. It would do 0 things for. So changing chapter to code section is a significant change. Additionally, we're trying to make sure that this doesn't talk about what the waivers are. We're just trying to set the limitations like the state has limitations on. The waivers already exist in the law. The waivers are already there. But if you look at the last part of section 6 of the 1507S, which is lines 118 to 120, they're trying to flip this on the head, or this proposal is trying to flip it on its head and say that this would be a waiver of sovereign immunity.
Mr. Chairman, can we have what he's looking at?
Yeah, you're looking at something different than we have.
Well, hang on just a minute. No, I thought I had that substitute that I was going to be the one who offered it. I'm not sure whether we're going to offer it today or not. I'm debating right now. I mean, somebody else may want to offer it. I'm sitting here debating now whether I want to try and fix this or if I want to just vote no, hearing all the problems you have with a potential proposed sub. I'm starting to lean to not offering it and making my decision easy. And so I guess that's kind of where my posture is in terms of me offering a substitute, Mr. Chairman.
Okay. You know, I think what's best right now is we make this hearing only and let y'all continue to work on the bill.
Sure.
All right. That's what we're going to do.
Can I ask a question, though,
You
Mr.
may.
Chairman? Did y'all take this to Governor Kemp to be included in his package?
We did, and we were informed by Governor Kemp that he would like to keep his package limited to business concerns, and cities aren't directly. The impacts here are going to impact businesses if we have large judgments in cities, and the two mayors will talk about that, but this isn't directly impacting businesses. So, yes, we did.
Okay, I got one more question. Is that Mom Tahan?
Yeah. Thank you, Mr. Chairman. I did have a question about kind of the way this may affect a municipality. And so if, let's say that we do cap these damages, is that going to change the way that, a municipality would prioritize maintenance? For example, if, I have the sovereign immunity and I know that I'm protected from gross negligence, right? Reckless misconduct. Am I going to fix that gaping hole in a bridge? And, you know, am I going to have the same desire to maintain those? And I think that's a question that we have to ask. And so, in some cities, when we think about cities, I used to represent a city who, you know, only had a police force so that the mayor and the council, who are all family members, could operate a bar within the city limits, whereas Paulding wouldn't. Now it's you're not gonna believe this. It's now in Representative Kelly's district, and so, you know, when we talk about cities, right? There's this larger discussion on what a city is, right? They're running radar without a 24-hour police presence, and so, you know, we talk about dichotomy and context and what a city is and what it isn't. Man, that's a huge, idea, and it varies so much. And you know, you're talking about cities who almost seemingly purposefully bankrupt themselves, and then trying to give some sovereign immunity or, you know, these kinds of caps from these damages. I'm just not sold. And then to know that they could also not do those things that is their mission to do, right? Provide those services for the constituents.
Sure.
And so I have some heartburn with that for sure.
I appreciate that. And I will say this, and I think the mayors can back me up on this, is that the cities absolutely would be working to fix issues just as much, if not more, if you had these limitations on sovereign immunity waivers. And I think one thing to really point out here is, you know, we haven't had a whole lot of extremely large judgments in the state of Georgia against cities currently. We've had a handful, and we're trying to get ahead of where these verdicts seem to be going. And Representative Reeves pointed out the Milton case. We've had a few others. Albany had one that was, I think, $15 million that was reversed on appeal. Brookhaven had one that was $6 million that was reversed on appeal. There were a few others in the $3 and $5 million range. And those might have been settlements as well. But what we're trying to get here is get ahead of a potential future issue where there's an important word you used, and you used the word bankrupt earlier. Georgia cities are cities, of all the states in the union, Georgia cities are one of two states where cities cannot declare bankruptcy. And so cities in Georgia cannot declare bankruptcy. So what we're end up in a situation is, if you had a $30, $40, $50 million judgment in Georgia against a city, they have no options to declare bankruptcy and work through that. Their only option is to raise taxes and reduce services and hope that's enough. Or they can give up their charter. And if they give up their charter, the debt is still there, and the debt becomes the debt of the county they're in. That's not good for anybody. That means raise taxes on the county level. So that's a real problem. And that's not raise taxes just for residents, it's raise taxes for businesses, residents alike. And that is a real problem. We are trying to get ahead of this issue before it becomes a real problem. On the 1 million, 3 million issue, you know, we are choosing 1 million, 3 million because that is what the state has on their current levels, right? We do not believe that cities can go higher than the state from our perspective. Now, your perspective may be different as a body, right? But cities do not have the budget of the state. I think everyone is well aware of that. While we might not have the same liabilities as the state, we don't have the same budget or anywhere close to the state. And so that's really important for us. But with that, I think I should turn over to our two mayors to give their personal perspective.
I've got a Christmas tree here. So
oh, good.
Representative Crawford.
Thank you very much, Mr. Chairman. I'm looking at this bill, and we have referenced the state. We've referenced different immunities, and just from someone that came from county government, there are certain things that the counties, municipalities, products of local government, such as the police department, I use as an example.
Sure.
So I'm curious as to why we are looking at the Georgia Torts Claim Act and the limit of 1 in 3 million there, and using that for municipalities, even though, again, there are certain areas that are distinct and unique to municipalities and counties like the police department.
Yeah, I mean, I think that's a good question. we have some of the same liabilities as the state, but we obviously have some different ones as well. The state runs a lot of correctional facilities. Most cities do not. So the state's going to have a lot larger liabilities with correctional facilities, but we do have law enforcement. The state has law enforcement, but does not have nearly as many law enforcement officers if you combine all the cities in the state. We are looking at that 1 million, 3 million number more because it's a limitation of liability for a government. The state has that 1 million, 3 million. We have the 1 million, 3 million. We could certainly ask for a lower number like every one of our neighboring states. And I think it's important to note, Representative Reeves pointed out that Florida has a proposed bill to go to 1 million, 3 million from 200, 300. And our contemporaries at the Florida League of Municipalities have that as their strongest opposition this year. And that has an escalator in it to, after 5 years, to go to 1.1, 3.2. And, I'm a big fan of escalators, but that is something that it shows the differences between Georgia and our neighboring states.
Okay. Chairman Smith, is that you?
Thank you. I just want y'all to know, I'm very impressed with GMA with your mention of the bankruptcy deal. Y'all's stock just went up with me a whole lot because I can remember I had a mayor back home say something about bankruptcy in a public hearing, and I could just hear Michael Mears, my evidence professor, in my ear saying that you cannot be a bankrupt municipality in the state because one of the few exercises of the 10th Amendment is to not adhere to the federal government bankruptcy courts. And so I want to appreciate y'all's candor in that. I hope maybe y'all could even send in a newsletter out to your mayors.
That they can't do it.
Tell the truth. You can't go bankrupt.
Sure.
I'd appreciate that because it puts us in a bad spot back home. Like I have to contradict city officials, which I don't like doing.
Mm-hmm.
So I appreciate that candor. My question is this. I'm interested in this dissolving of the charter. I would contend in certain areas, especially in rural Georgia, if they became part of the county, their tax probably go down. They're paying a little extra by their right of self-determination being a city. And so I've seen that. And so my question, though, being to get to the point is, if you dissolve your charter, I mean, does the jury award have to be paid by the county then?
Yeah, so for my understanding is if a charter is dissolved, the debts and liabilities of the city become debts and liabilities of the government they become part of, which is the county. I would also say that, cities might have higher, not always, but cities might have higher taxes even in rural Georgia than their county contemporaries. But cities often provide a higher level of service and more service than their county contemporaries. Especially in rural Georgia, cities might be the only place where you have water sewer instead of well septic, and so those are big differences in services. And you may have only the sheriff in rural parts of Georgia, whereas the cities would have a police department where you have a more concentrated law enforcement presence in a more denser part of the city or the community.
Thank you for that.
Yep.
And Representative Evans.
Thank you, Mr. Chairman. You were talking about the subject of insurance earlier, and I know the city of Atlanta, or at least I think I'm right, that the great city of Atlanta is self-insured. Are there any other cities that are? Don't all other cities buy general liability insurance?
I don't have the answer directly on my head. I do believe there's a few others that self-insure. She's
if you could get those stats for us, it would be helpful because what I heard you say is most are self-insuring, and that is not my understanding, and I just want to get clarity.
Yeah, that's absolutely not true. Most have a policy of insurance. There's a few that have self-insure. Okay. So most have a policy of insurance, and I think it's important. Another important factor here is most cities' policies of insurance contain a $1 million or $2 million, something like that, policy. So if you have a $10 million, $15 million, $30 million judgment, and your budget is $2 million or $3 million, that's a real issue. That's a real issue for that community, for everybody.
And one other question, if I might. I heard you say this is mostly to, I think you said to get ahead of potential issues in the future, and that's what any good government would do, any good business would do. But there's more than, to me, there's a couple different ways to get ahead of something. And Maybe somebody from Milton is here, and maybe you or the other mayors can speak to this. You can get ahead of it by limiting your liability, which is what you're here asking us to do. Cities could also get ahead of it by doing a risk assessment.
Sure.
If Milton apparently had listened to complaints for years and years and years, that boulder wouldn't have been there, and we'd still have a young man who. But let me finish my question. So I guess there's a question about if Milton could come and speak to what did they do after this to evaluate, what did other cities do to evaluate where their risk factors may be. And I'm going to give you one quick story. I just had this terrible pipe burst plumbing issue, and I have this 100-year-old house that I love that I use for my law office. And it freaked me out. It was really scary. And so I've hired somebody. What are the pitfall areas for a house this old? What else can go wrong? That's how I'm dealing with it. And I've yet to hear in all of this tort reform talk and this here today, what are the cities doing to get ahead by evaluating where they have risk to their citizens?
Sure.
And not just coming here and asking us for limits on liability.
Absolutely. And so, I can't speak for every city, but I do believe that most cities are taking risk assessments and going out and trying to fix issues as they're presented to them. And I don't want this to become a debate on the Milton thing, because this is bigger than Milton, but to correct some things with Milton. First of all, Milton is active litigation pending before the Georgia Supreme Court. Second of all, it was a planter that was in a fork of a driveway about 6 or 7 feet off the side of the road, and they had received 0 complaints or accidents for that, and that planter had existed 30 or 40 years before the city existed. So there are issues there. But probably the biggest thing related to the Milton thing is all the case law before that had said that issues of liability for a city are things that relate to the actual use of the road. The use of the road. So things in the roadway or things next to the roadway that reach into the roadway. And in fact, during this incident from Milton, which started in 2016 to still going now, there was a case out of the Georgia Court of Appeals called Smith versus Roswell, where another driver left the roadway, hit some mailboxes, killed himself and his daughter, and the Court of Appeals said the city has immunity in this situation. And so almost the same situation, and the Court of Appeals says city has immunity, but in Milton, the city does not have immunity. And so it's really hard for a city to say, okay, we've gotten no complaints, we've had no incidents, it's 6 or 7 feet off the road, and maybe we should have known about it, but did we really get any complaints about it? And then see all the case law going into it saying it's not impacting the actual travel lane. And so it's hard to you can understand how that would be hard for a lawyer that's representing the city in that case to analyze that situation.
But our cities, you're here trying to get ahead of it by asking for liability caps.
Sure.
Can you represent to this body that the cities are also taking risk assessments of dangers to their citizens? Is that happening too? And if it's not, why not?
I think it is happening, but I think the two mayors can talk a little bit about how that works in their communities.
And then last question, are you sure that the city of Milton did not have complaints and warnings about the planter?
Everything I have received that says that they never got a complaint or warning about that planter. The only thing that came up in the trial was that the city did road work in 2012 and should have recognized that that planter was in there right away.
Thank you.
Vice Chair Reeves.
In the interest of getting it all out there, the city did know that people were hitting deer on that roadway, and it was foreseeable people might leave the road.
That's true. The city knew that there were deer in the roadway, but I mean, it's Georgia. There's deer everywhere. So,
and y'all had brought this up in years past prior to that larger verdict, right?
Yeah.
And here was the question I wanted to ask. There was a question about the statistics. Isn't it true that this year's proposed state budget, the governor requested $175 million to pay down a much larger total of claims against the state under the $1 million and $3 million?
That's absolutely true.
Okay. I'll go with the witnesses you've brought with you.
I'll turn to Mayor Ward first.
Thank you, Mr. Chair, for letting us be here. I'm Kurt Ward on behalf of Brownston. Honored to be its mayor. Honored to be in front of you all. Thank you for your service to the state of Georgia, to your local communities. When I was asked to talk on this, it actually brought back recollection to me of campaigning and how you go door to door and campaigning. And I'll give you a war story that I spent 45 minutes, nearly an hour, sitting with a gentleman, talking about his issues and one-off issues that are important to him. And as I neared the hour point, I said, "Sir, if you don't mind, I'm going to try and meet a few other people today." To which but I said, "I sure would appreciate your vote." To which he responded, "Oh, I'm a convicted felon and I'm not able to vote." So we realize when we go door to door to folks, and in Brazelton, people would say to me, "Hey, Mayor, we would love a bowling alley," or "Hey, Mayor, we would love an ice skating rink for my kid," or "Hey, Mayor, we would love a roller skating rink if you could do that as a city." If it were up to my wife, she would love a Lululemon and a Trader Joe's, right? Like all kind of things people will want as a one-off, but as a city, we have to understand that what may be good for one may not be good for everyone. And that's a decision that we have to make again and again and again. And when the people of the state of Georgia adopted our Constitution and stated that the state level of government, the county level of government, and the city level of government have sovereign immunity, and then it's up to you all to waive that sovereign immunity, and you can waive that to whatever limited amount you want to waive it. I truly believe that cities are akin to that, and in my city, one way we're akin to that is we have a charter that we operate under, similar to how the state of Georgia operates under a constitution. In Brazelton, our charter allows us to impose property taxes. We do not. We find ways through business means and hotels and alcohol and right-of-way, franchise fees and things of that nature to cover our budget, which is $10 million a year. But I can tell you, flat out, if Brazelton were to get a $10 million judgment against us, we would immediately impose a property tax, and it would come in at 13 mills. Many people, that's on a $10 million judgment, right? Many people have been complaining, and we all understand the industry of housing that's happened in the last decade or so, right? The 2010 era depressed the cost of housing and depressed what homes were worth. A lot of short sales, a lot of foreclosures. People were to buy homes at a lower rate back then, right? 2020, the COVID era, well, we all know the supply chain dried up. The demand was enormous for housing, and now the cost of housing has gone way up. There's probably not a decade of difference that's caused that substantial difference in the valuation of housing. I even had some constituents talk to me and say, "Hey, my home didn't get evaluated, but once every 7 years." And I said, "Well, then you probably left money on the table. You're not complaining about that." But then that 7th year rolled around, and all of a sudden the valuation of our home was through the roof. And I know that's an issue you all are hearing about because the representatives that I work with from Brazelton talk about that. But think about us rolling out a 13 mil addition to what those homes would pay. Think about the impact of that on businesses if businesses have to roll that out. And what I did is I tried to just say, hey, how do we, take what Brazelton's example is? Because y'all don't know the details of how Brazelton works. You don't understand the services we provide. I would absolutely be remiss if I didn't say that sewer is an unbelievably important service that our city provides. We have a hospital called Northeast Georgia Brazelton. They're adding 500 new rooms. At 200 square foot a room, how many times do people wash their hands and flush toilets in that 200 square foot room? And we provide the sewage for that. It's very extensive, right? We have over several thousand hotel rooms. We support Road Atlanta, which brings additional, people to Georgia from all over the world to participate in those events. And without a sewer department from a city, that's done. That's over. There's no opportunity for that. But when I looked at it and said, hey, how do we run some numbers to help you all wrap your head around the true impact this would have on cities and those businesses? And I've got a handout if you want to see these statistics kind of broken out in stats. But if you take a city that's got a $1 billion tax digest, right? Just try and run those numbers real quick. And the way I matriculated those numbers is take about 5,000 people in a city. Let's take about 2.5 people per home, right? So you're looking at 5,000 people, that's roughly 1,500 homes. And let's put those homes at an estimated value of $400,000 each, right? That's going to give you a tax digest of $600,000 or $600 million. And then let's put a $400 million business tax digest with that as well. Okay? So you see the size of the city we're talking about. I'm calling it Smallville after Superman. It's a random example, right? $1 billion city, you got a $400,000 home. If your city faces a $10 million judgment, your immediate additional tax bill on top of what you're paying is $4,000. Look at a $25 million judgment, your immediate tax bill is $10,000. That's going to impact homeowners, that's going to impact businesses, and that's on a $400,000 home in a $1 billion community. There's a lot of communities that don't have $1 billion of a tax digest. President, we're blessed to have over $1 billion. We have over $2 billion of a tax digest. But you put a $30 million verdict on Brazelton, you're looking at a 45% mill coming in at the front end. You put a $30 million judgment on this Smallville I'm talking to you about with $1 billion in assets. That's a 70 mil increase in taxes. You talk about phone calls. And this is where I wanted to close on this. There are going to be some people calling their relatives crying. They're going to lose their home. There are going to be some people calling me as a mayor, how did you let this happen? There are going to be some people calling you as a representative saying, wait a minute, we're being told that you could have limited this liability under the Constitution that the people of the state of Georgia voted on. You could have limited how much you waive that immunity, and you didn't. And for my city to survive, this is what I've got to do to make it survive. It's a policy choice. It's a hard choice we make. It's not an easy question. I can be joking and talk about Lululemon or ice skating rinks. But what may be good for one may not be good for everyone. And we've got to look at that and how we're going to handle this type of situation. And how you can look at cities and whether or not we're really important to the state of Georgia. I would submit we are. And we look forward to continuing to serve the citizens.
Rarely have I been accused of being soft-spoken, so I think I'm probably close enough. Good afternoon, Mr. Chairman and the members of the committee. My name is Bianca Motley Broom. I serve as the mayor of the great city of College Park and the first vice president of the Georgia Municipal Association and chair of GMA's Legislative Policy Council. In my view, this is really an issue of parity. There is nothing I would like better than to fix all the potholes. That's what our job is. It is to do the work of our communities, to use our resources in a way that helps each and every one of our residents. For me, it is 13,930 of them. I am so proud to serve our community. But with the way that things are right now, we are in jeopardy. We are in jeopardy of being able to provide those services. I want to make sure that everyone's trash gets picked up. I want to make sure that we are providing appropriate police and fire responses when we get those calls to 911. But if College Park received a verdict of $10 million, our millage rate would have to go from 11.608 to 18.748 mils. That is a huge increase for our population. It's not just about homeowners, though. It's also about our renters. College Park has about 75% of our residents that live in renter-occupied units. People often forget about the fact that renters are very often some of the people who are most cost-burdened in terms of their living situations. When landlords would get this property tax increase, they're going to pass it on to the people who are renting from them. Talking about businesses, you heard Mr. Patel talk about the governor's priorities in regard to tort reform, but this would get passed on to our businesses as well. Business owners make decisions about what communities they want to land in, where they want to be to make sure that their businesses will thrive. This is a vitally important part. How much are they going to pay in taxes? They will pick other communities if we do not have some level of protection. But a little bit more about my great city, which is 11 square miles, and part of which encompasses Hartsfield-Jackson Atlanta International Airport. In fact, if you go to the arrival, departure gates, the T gates, the A gates, or the southern half of the B gates, you're in the city of College Park. And we are a hospitality city. We have over 35 hotels in College Park. We have to provide services to so many visitors that come to our city. That is in jeopardy if we have a large judgment. Think if there's a fire in one of these hotels and we don't have sufficient firefighters to show up because we've got to cover a judgment. The choices are we raise taxes, we cut services. Those are pretty much the choices that we have. If we can't provide the right level of service, that doesn't mean that that's strictly limited to an impact to College Park. Because we are a community that is the gateway to the world, people come to Georgia and they come to College Park. We are key to the entire economy of this state. We need to be able to provide appropriate levels of not only service, but of taxation of our residents and our businesses and those who come before us. So I would ask for your consideration. I know that there are lots of questions, and I think that there's an opportunity for us to work this out. But I don't think doing nothing is an option. We need to have the conversation so we can keep on filling those potholes, so we can keep on making sure people's trash gets picked up, and being able to provide the core services that so many of our residents depend on. Thank you so much.
Okay. Got a couple of questions here. Representative Evans.
Thank you, Mr. Chairman. Thank you to the mayors. I get it. If you got a verdict, either one of your cities, for $30 million or something similar to that, it would be bad. And you're here telling us that you know that. And this was the question I posed to Mr. Patel. What are you doing to make sure something like that doesn't happen? What are you doing to review your hiring practices to make sure you're not hiring, city workers who are going to be in city cars that are going to act negligently, or some inspector who's going to go into someone's house and do something that they're not supposed to do, or evaluating trip and fall hazards? I mean, there's more than one way to deal with a bad verdict. It's like somebody comes to me and says, I can't do something because this bad thing happened. I'm like, well, what did you do to avoid the bad thing? That's the question that I posed, and that Mr. Patel had volleyed to y'all, but I didn't hear that addressed at all.
You are correct, Representative Evans. I did not address that. But our city does have a risk management component as part of human resources. So that is something that we work with outside entities to help us mitigate our risk. But the reality is that we can't plan for everything. We can keep on trying and we can keep on working to try to be better, but there are always risks that we're not going to be able to appreciate at the time.
What about providing insurance coverage?
We are self-insured up to, I don't want to quote you on that because I wouldn't want to be incorrect, but part of that has been because we are not a city that at this point insurance companies necessarily want to insure. That's already happening.
Mr. Mayor.
Yeah, thank you. Just to give you a perspective of some, not so urban cities, we work through GERMA. We carry insurance on our vehicles and on our general liability, right? We're a proud member of GERMA. We're happy to support them as an organization. What we do, just our general email gets a few pothole notes every now and then. It's sometimes kind of like a classroom. The best way for a teacher to run a classroom is all the students telling each other, right? So our constituents tell us of all of our failings quite often. But in Braselton, we also have a protocol that we've instilled where we have a third party come in and evaluate our staff and evaluate our organizational structure and evaluate how we're doing things. Because since my tenure has began, we realize, hey, the board, it doesn't have the industry knowledge, as a board, that some of these people that do this, for a living for 30 years do. So, candidly, right now we have the Carl Vincent Institute with the team evaluating Braselton has over, I think, 40 years of citywide experience evaluating us and seeing how we're doing. And we're proud to do that. We feel like that's an accountability measure that we're taking for our constituents to make sure we're running an efficient government financially, but also looking out for these types of things.
And if those reports find yellow flags or red flags, do y'all act on those?
Yes, that's what we're actively addressing. In fact, I meet with them roughly every 2 months to say, hey, how's the report going? What are we doing? Is there anything in the meanwhile we need to look at? And that's things we bring up in our routine work meetings. So I do understand that people have exposure to someone in a police department like that may not be operating under the normal guise of what I feel like my city does. As far as someone operating a police department, just operate a bar. I've never heard of that. I'm sorry that happens or whatever. In Brazelton, we mentioned frontline services, and we mentioned, hey, well, what if the city just goes away and the counties just handle it? My city's on the corner of 4 counties: Hall, Jackson, Barrow, and Gwinnett. We provide over 100,000 police calls per year. We provide mutual aid, which is where Brazelton's police officers actually cover for the county police officers on many of those 100,000 calls per year. To think that service would go away to the corners of those counties, which the counties teach usually in the middle, and you got to reach that police department out to those edges. I think it really would impact the counties greatly if the city went away from the police perspective, in addition to the sewer and other services perspective. But hopefully that answers your question. If I didn't, please follow up.
I appreciate the answer. I'm thinking of, you get these reports back when you do a risk evaluation or something like that. I would assume there's some committee or board or something that decides, okay, we're going to make a risk. You said you got a risk management department is going to decide, okay, we know this is a potential risk. What if the worst thing happens? If the worst happens, that this risk is revealed, what's the consequence? And then you weigh those and decide what to do, right? Right?
Yeah, these are judgment
Generally,
calls
yes.
we make
Yes.
all the time.
And so these liability caps that you're asking for would then be part of that evaluation and deciding what to fix and what not to fix, wouldn't it?
Honestly, I don't think so. I think that we try to provide the best service that we can to our constituents. And what you may find surprising is when it comes to right-of-ways and things of this nature that often impact a lot of people, even on county roads, we petition counties to hand the maintenance of that over to the city because we do such a better job. But we constantly evaluate, what are we doing to make sure our city's safe? And that's why we don't want to give up our police department. That's why we don't want to give up, the services that we do provide.
And to Mayor Ward's point, I understand that there are going to be bad actors in every group, but there are 537 cities in this great state, and as an officer in GMA, I've had the opportunity to be in every corner of this state and sit and learn and fellowship with local elected officials who get up every single morning trying to do the best for their communities. And that's what we do. That's how we look at our cities. We go through them and we try to do the best that we can. I don't see that the state is somehow disincentivized to do what the state needs to do with these caps. They are still providing they are determining what their risks are and trying to mitigate those risks. And I don't think that city officials would somehow slack off on the job because, we've got these caps, we don't have to do as much. There's always more to do on the city level. It is amazing, incredible work that you have to love to do it. And I just don't see a majority of our local elected officials thinking this would be some reason that they could do less work.
To give you a classic example, I was called out to Summerall Circle in the Riverstone neighborhood of Brazelton, right? a busted sidewalk prevented school-aged children from what parents claimed safely, giving them an opportunity to get on the school bus. We took it out of our council budget. We took it away from what the council could do to take retreats and grow as a council to make sure the sidewalk got repaired within a matter of days. This is life at the city level.
Mm-hmm.
We're frontline with people. I can't go to the bathroom at a Mexican restaurant sometimes because my wife's like, you'll get stopped, and I don't want to deal with that. I understand some members of y'all's body say, hey, it's just really different when you get down here because people aren't as close to you. But when you're the mayor of your city at home, you're not, and it's brought to your attention. And I do not believe, and maybe you just take a completely cynical view of this, that, hey, you get a limit of your waiver. We believe you should have unlimited waiver and just complete exposure for your city to get for it to get, exposed to this type of verdict. And if you don't have that type of pressure on you, you're not going to provide the services as best you can. It's hard for a person that does this every day and talks to the constituents every day to hear that or actually feel like that's the view that could be imposed on.
Well, last question. Everybody at this table, except for Mr. Patel, who we love, is an elected official.
Right.
And I appreciate what you do, but our job is we want to protect the cities, and we want to protect the counties, and we want to protect the state, but we want to protect the people. And, they don't have a lobbyist to come down here and talk to us about things. And what I look at, and this is my last question, Mr. Chairman, is this is the question that I ask myself, and I'm going to put it on y'all. Yeah, I have no doubt that y'all care. You wouldn't do it. You're not doing it for the money. You're not doing it for the glory. God knows everyone at this table knows that. You're doing it because you care. But you can't do, what I'm hearing is we can't do everything. We don't know. We're doing the best we can. So when you've done the best you can, but something happens, you do have a bad actor on your staff. You did miss something on the sidewalk. Who's in a better position to protect against the loss? The little school kid who gets hurt or, God forbid, killed? Or the city and county, we're not talking about counties, but the city officers who could have maybe paid a little more for insurance and taken care of that? Who's in a better position? I think the answer is the cities and not the little girl. But I want to hear from y'all.
I thought you would have a thought about that.
Yeah, so one thing I want to point out is I think all our mayors, our council members, GMA, we want to protect the citizens of this state as well. And I think, we easily could have asked to bring legislation that put our waiver of sovereign immunity at the same level as the counties. We did not do that because we do believe that if the city does something wrong, then there should be compensation for that. And that's why we're trying to tie it to the same levels as the state. But when you're looking at protecting the people, you can't just look at protecting the person who was harmed. You have to look at protecting all the people in your community. And if you have a $10, $20, $30 million judgment against your community, then, as the mayor's elaborated on, you are looking at a situation where you are taking away from public safety, from infrastructure like water and sewer, to the detriment and to the detriment of the safety of the rest of the people in the community. We're trying to find that balance.
Yeah.
Could you answer my question, though? I mean, I get
think
that. I get that if the worst, I get it. If the worst happens, I get it. And I love y'all. I'm so glad I love local government. I love my city. I think the creation of all these cities in this state has been great because I do think that government closer to the people is better. But we don't have to get to that place where we're going to have to get rid of the fire department and the police department. That's Chicken Little language. You could make a decision to cover these potential pitfalls, for lack of a better word, with insurance. And I guarantee you, I'm guessing, I don't really know, I don't have a crystal ball, but I feel pretty confident that if you surveyed the citizens, the parents of your district, and you said, of your city, and you said, would you pay a little bit more so that we could get insurance so that we can make sure if the unexpected happens and a little kid is dead, that the family can be compensated, or that we can take care of those things on the front end. I appreciate that. I get what you're saying. If you get the $30 million verdict, the citizens suffer. But who's in a better position to make sure we never get to that? And I
Sure.
think it's y'all. And if you don't think it's that, I want to know why.
Well, so on the insurance point that you just made, is so yes, most cities have a policy of insurance. Mayor Ward is in Gurma. Mayor Motley Broom has they self-insure. And, I mentioned earlier, most cities have a $1 million or $2 million policy. And they might have reinsurance for, $750,000, another $1 million or something like that. But when you start looking at the larger numbers, $10 million, $20 million, $30 million, it is very difficult to get policies like that and make the value judgment that how often are you going to have a claim of $10 million, $20, $30 million, and how expensive is that policy if you can even get it. And most of those policies would be very difficult to get. You could probably go to Lloyd's of London or something like that. But
Mr. Chairman, I'll stop. I'm not getting an answer to my question. I don't think that, has there even been a $30 million verdict other than this Milton situation? But
and that's what we're trying to get ahead of. And I think the situation in Milton, they have a $30-something million judgment, and I think their budget is $40 million. And so you say it's Chicken Little, but it's not Chicken Little for Milton. And so in Milton's situation, if this judgment ends up being affirmed, or if the Supreme Court doesn't take the case, they're going to have to figure that out. And Milton has a property tax cap in their charter. And so they can't raise their mills from 11 to 18 or 0 to 13. Their cap is at 4.6. So they're looking at...
because maybe somebody should move the
Okay. Chairman Smith.
Mr. Chairman, I'm not trying to be repetitive here, but I have to ask the question, in the last 5 years, who has had to dissolve their charter because of this judgment being awarded against them?
So no cities have had to dissolve their charter because of a judgment?
In the last 5 years?
There's only been 2 cities that have dissolved their charter in the last 5 years, and it's not because of a judgment.
Okay, what about the last 10? Any?
I don't think any for the last 10, but, I haven't looked that far back.
What about 50?
So that's a good question. I don't know about that. But the issue here is we're trying to get ahead of the big judgments. We're not looking at all these massive judgments from 20, 30, 40 years ago. We're trying to get ahead of this so we don't have this problem in the future.
I understand being concerned about that, but, proactive in anything that government does, whether it be at the city, the county, or the state level, seems to always come at the expense of the citizens' rights. This proactiveness. I mean, and the reason I'm looking back, you go back to this, we trust the experts. And I love the Carl Vinson Institute. It's great. But every single time I have a local official contact me, it's from talking points that are given out at seminars they go to, that they have to be certified to serve as an elected official. And so part of my frustration is that they're just regurgitating this, and then we get into the meat of the matter, and once they hear the other side of this, it's a totally different thing. Mm-hmm. And so I'm glad y'all got walking around since, and y'all are the most sincere of any mayors I think I've ever heard testify. And I appreciate y'all's sincerity. But if wishes were ponies, we'd all take a ride, and I just can't always think that we'll have officials that come after y'all that would be so gracious in making sure that y'all take care of your citizens. I saw this in the District of Columbia. During the inauguration, I was staying up towards the diplomatic district. And it was interesting to me, with the snow and the ice that had fallen, certain parts of the city had plenty of salt, and the sidewalks were de-iced. Not in the diplomatic district. There's a long conversation about this. One of the more, progressively minded areas in the whole country, still in a minority district, was not providing services for that area. Where visitors, those members of the diplomatic corps, live and eat in those bagel shops and great Italian restaurants up there. That's what I worry about. I don't think y'all would ever do that, but I've seen it firsthand in other areas. So I appreciate y'all's sincerity, though.
Okay. Representative Montahan.
Thank you, Mr. Chairman. actually, I want to go back to, I think Mayor Ward, you were saying that you had an experience where you had a group of, I think it was moms, right? Is that what you said? A group of moms had kind of reached out to you and said, hey, we believe that this is a danger to our children. And at that point, the city took action. You took money out of different budgets. You said, hey, we can't go to the retreat. We can't do this. We can't do that. We can't buy that extra bus or whatever it may be because we have to fix it. And I would say that at that point, that, you know, look, that we are rationalization machines, right? We try to rationalize things in front of us. But I can't help but say, well, isn't the reason that you fixed the sidewalk so it wasn't a danger to children because you knew if a child got hurt, you would be liable to these lawsuits? And so in that case, you did the right thing, right? A, you're serving the purpose of protecting the children. But B, what held you accountable was the potential for a lawsuit. And so I can't help but see that the law that exists today is working.
I would disagree. I think that's a completely cynical and a little bit degrading perspective that we don't fix things in our city without thinking we're going to get sued and have to be dissolved as a city. That takes away from our love of our constituents, our pride in our city. If that's what y'all think of us, I can understand that. But you don't work like we do. You don't walk the streets we do. And, you know, we're trying to look out for the long term of our community every day. We make decisions that affect us for the next 5 days. We make decisions that affect us for the next 50 years. And, I appreciate your comment. I really do. But this goes back to me that what may be best for one, and what I do think is being missed here, is think of y'all's questions about how many verdicts have been $30 million verdicts. Look at what cities have done for decades in Georgia to provide as many services as we provide, and we don't have these. Any verdict that's been issued against our cities has not been this high. So the numbers we're talking about are likely within the range of where these types of decisions against us would be anyway. So I don't mean to be disrespectful to say that I take exception to your comment that we wouldn't fix a sidewalk unless I thought I was going to get sued. We fix a lot of things in our city every day, and our staff does quite a job in doing that.
Yeah.
All right.
Mr. Chairman, if I may. I'm sorry. Oh, wait.
Go ahead.
Thank you, Mr. Chairman. And again, thank you, Mayor. I think that you are sincere. I really do. However, there's a lot of cities out there. And from our perspective, dealing with all these cities, we see the other side of that coin. And we don't always get somebody like Brazelton, right? We get the Braswells. And that's the issue, right? So thank you for taking care of it proactively. But unfortunately, we're not so blessed to have everyone doing the same thing. Thank you, Mr. Chairman.
All right. Oh, sorry. Representative Kelly.
Thank you, Mr. Chairman. I want to be consistent this year as we approach these measures, these type measures that are coming before us, tort reform. And one thing I'm gonna be consistent in doing is every time someone comes to me saying nuclear verdict or big judgment, or every time they bring me one of these outlandish, what they consider outlandish awards by, a jury of their peers, I'm going to say, what was the first offer made to resolve the case? And talk about how some of these problems could be avoided if people started negotiations in good faith. Do you know what the city of Milton, and I don't want to just talk about city of Milton, but they're being used as an example, so we have to talk about their facts. Do you know what they were able to, and this is not a question to pick on you, I'm going to ask every group that comes here and ask me about big verdicts, I'm going to ask them if they can also give me the starting points of those negotiations. So do you know what the offer to resolve the case in Milton was first from the plaintiff and what the response was from the city?
So I can't speak to the responses. I wasn't the litigator involved in this. I do believe that it's public knowledge that the first offer in the Milton case was, I think, 1.75 million. And I believe that offer came very early in the situation. It might have even come before the surveys recognized that planter was within the right-of-way. But I think it takes away from the overall lay of the land on the law in that situation, is that, again, all the case law up to that point had said that the city should have had immunity in that situation because it wasn't in the travel lane. It was not in the travel lane. So as a lawyer who would have been representing the city in that situation, they would have looked at that case law and said, okay, the case law says we should have immunity in this. And that makes it a very difficult decision when you're trying to say, I offer a 1.75 settlement offer, but the city's representative is looking at this and saying, well, the case law says that we should have immunity. And we haven't gotten to court yet, you haven't done discovery yet, you haven't done anything of that.
Trying to avoid excessive litigation.
Yeah, and so trying to avoid excessive litigation. So the city may have, and I don't know this, but the city may have made another offer that was lower than 1.75. I don't know. But I mean, this is that negotiation process. The city's going to have to evaluate it based upon what the law says at that time. I do know this, is that after that Smith versus Roswell decision came out that said, you know, the driver left the roadway and hit some mailboxes, which was very similar, and then the Court of Appeals says that there's immunity there. The next offer that came from the plaintiffs then was $10 million. So how's the city's lawyer supposed to look at that situation and saying, well, we just had a case that affirms our position that we should have sovereign immunity here, and then their offer is $10 million. That's difficult. And I wasn't involved in that, but I mean, that's a difficult call. And I mean, we're still in this situation, you know?
And if so, to help me, as I keep a spreadsheet of these throughout this debate we're going to have this year, before you come back, can you figure out for me what the offer to resolve, the first offer to resolve was from the city, that they could have done that, and any other verdicts we're going to talk about that you're going to put a dollar amount and call it outlandish? Can you also bring, and I'm going to ask every group that comes here to give me not only give me the number they want to throw out the shock. I'm going to ask them to bring what was your first opportunity to resolve that matter, and then how did you respond to that. So please, those three numbers will be helpful for me as I consider all these throughout this process. Thank you.
Okay. Representative Reeves.
Mr. Patel, I think you said that the city may not have known a lot at the time the claim was presented. The substitute that I've filed doesn't have anything about the anti-litem notice period, but the state and counties have a year and cities have 6 months, right?
That's correct. That's correct.
Okay. And the current version doesn't have any change in that?
That's right.
Okay.
All right, that's all the questions.
You've had 2 long bills.
Yeah, didn't expect it, but that's okay. We got one more to go, and it should be a quick one, right? Oh, yeah. All right.
Thank you, Mr. Chairman, and
I want to thank y'all for coming here, and appreciate what y'all do and what you've given us testimony about.
Thank
Give
you
us
so
something
much.
to think.
Thank you.
Okay.
Thank you.
All right. Representative Montahan. Motion to table? Okay. We got a motion to table. All right, this is House Bill 378 LC 481455, and Representative Montahan, if you would tell us about it.
Thank you, Mr. Chairman, and y'all should have a committee sub with all 96 sections. No, I'm kidding. Y'all, this is a very simple bill, very quick. After talking with some attorneys that were in my district, this just simply states that each state court clerk shall be required to publish and maintain information in dates regarding the terms of court in a prominent location on its website. so that all council can be informed of what those terms are. Right now, they're kind of buried. You have to go searching for them for state courts. And if it's a state court that was, created in 1818, it's pretty tough to find those terms of court. You got to go through a lot of paperwork. But now, if it's one of these newer courts like Paulding County, well, the terms of court have never changed. And so this just kind of gives a clear and equitable understanding of when those terms of court are, and I'd appreciate your favorable consideration.
At the appropriate time, Mr. Chairman.
Now's the appropriate time.
Second.
All right, we got a motion and a second. All those, any further discussion?
I would just say this is the best bill he's ever brought before.
All right. All those in favor say aye. Aye. Any opposed? All right, your bill passes.
Thank you, Mr.
We're
Chairman.
done. We're adjourned. I got to stand up. Yeah.
Oh my God.